Participants, welcome to the technical session 4 of the two-day international conference on private international law in the era of new emerging technologies, issues, challenges, and the way forward. To begin the session, I would like to respectfully invite our distinguished guests, session moderators, and presenters to kindly come onto the stage. I request Professor Dr. Benajit Chakra, Dean, VIT-AP School of Law, Professor C. Gerard, Executive Council Member, Indian Society of International Law, New Delhi, Professor Amrita Gulshan, Assistant Professor VSL, and our session moderator, and presenters Dr. Abhishek sir and Professor Dr. Vadam. Thank you. Thank you so much, sir. We are honored by your presence. Now, to formally commence this session, I would like to introduce our esteemed session moderator. It is my privilege to introduce Professor C.H. Amrita Gulshan ma'am, Assistant Professor, VIT-AP School of Law, who will be moderating today's session. Ma'am is a distinguished academician with expertise in international law and space law. I now request Ms. Amrita Gulshan ma'am to kindly deliver the opening remarks and take the session forward.
A very good morning to everyone. After an enriching first day session with all the technical rounds and all the guests of honor and chief guests giving such wonderful piece of information, we gather here for the second day and this is the first technical session to discuss various dimensions of private international law in the new era of emerging technologies, issues, challenges, and the way forward. We hope to have a meaningful dialogue, enlightening our thinking ability in the diverse topics that are carefully picked. We are honored to have our eminent professors, Dr. Banerjee Chakra sir, Dean VSL, and Professor C. Gerard sir, Executive Council Member of ICPIL. May I take a brief minute to introduce our keynote speakers today. Dr. Banerjee Chakra sir, Dean VSL, graduated from Andhra University with BA LLB Honours and LLM from South University of London and obtained MPhil and PhD from Centre of International Studies, JNU. He also earned postgraduate diploma course in teaching, learning and research in higher education, National University of Ireland. Dr. Banerjee Chakra was previously associated with professorship and Dean of Alliance School of Law and also Associate Professor and Registrar of National Law School, Assam. He has got distinguished publications and various expertise knowledge in the field of international law, space law, aviation law, and he also chaired Jessup Moot Court competition and various other achievements, just to name a few. Now I would like to give a brief about Professor C. Gerard sir. Professor C. Gerard sir possesses 30 years of standing at bar in 3 Commonwealth jurisdictions with expertise in international law. He holds a degree of Masters of Law in Constitutional Law and International Law from University of Madras and Masters of Philosophy from International Law in Jawaharlal Nehru University. Practiced law before Madras and Delhi High Courts and Supreme Court of India. He also served as barrister and solicitor in the Republic of Nauru and as Principal State Counsel in Attorney General's Chamber in Republic of Seychelles. He was legal advisor to Seychelles delegation to European Union to negotiate sustainable fisheries agreement. He started as senior researcher investigator at Indian Society of International Law, and then he moved as legal officer in the Secretariat of ALCO. He also conducted research on various international issues and legal issues. He also served as director and then secretary general of ICPIL from 2003 to 2006. He organized various global level conferences on international law and obtained major recognition in the same. He's an author of various international law books and also a chief academician. Thank you very much, both the keynote speakers, for gracing your presence here. May I now request the keynote speaker one, Professor Banerjee Chakka sir, to give your kind address.
Good morning to all of you. I think there are a number of students are there in the auditorium, I suppose. Good morning to all of you. Yeah, just look at what speakers are speaking instead of getting close to your gadgets. Okay. So indeed, it's a great privilege and honor to speak and share the dais with legal luminaries and experts of public international law and private international law and practitioners of international law. And it gives us an immense pleasure. And this is the second occasion we are trying to draw these experts and practitioners to the part of this country, particularly Andhra Pradesh and Vijayawada VIT-AP University. And in year 2024, we had an opportunity to conduct the same level of organizational mechanism, that is a national conference on public international law and challenges. And it was well received, and 2 days we had an opportunity to discuss the contemporary issues of public international law, and we continue to progress, and we are disseminating the discipline of international law, both public and private, in this university. And to have the more meaningful approach and also to take it forward and to have the diversity of the subjects and to make our young students aware of the very good practice areas. So we decided this year to have a private international law, particularly when we are all confluencing with the ideas of new and emerging technologies. And we all know that this new and emerging technology now today, we are reaching a threshold point. We are not only discussing about its technological invasions to the human life, but their impact on the day-to-day transactions and its forced obligations towards the individuals. And also it is very interesting to see that the state government of Andhra Pradesh and our VIT-AP University are also making an attempt to have the quantum technologies. So that means this is another level of technological experimentations and innovations they are doing. So when this kind of technology is forcing us to think, and we as a lawyers, and we have to look at its ramifications, its impact, and its effect on the day-to-day relations of the people. The last 2 days, we have yesterday we had different aspects, starting from that traditional areas of private international law, be it a jurisdiction, our choice of law, our choice of forum, our enforcement. We have discussed that is a typical issues of domestic law. When it has gotten a foreign element, there is no typical contractual obligations and no jurisdictions is found. If there is a conflict, obviously we have to rely upon the private international law. And morning when I was talking to Gerard sir, he was asking, and why we are not having a local lawyers. And the local lawyers have the deficiency of understanding these subjects. The reason being, this part of the country did not get exposed to. Today, I'm not talking about the earlier. Today, most of the law schools and most of the people, those who are graduating and practicing the lower courts, many people, they did not even hear about the subjects like private international law and other things. Then what happens if there are any issues and they come to different places, they approach. And we have that legal aid forum in the VIT-AP School of Law. And people come to know that there is an incident which happened. A commercial merchant shipper who was frequently voyaging in a commercial ships, he fell in love with a Brazilian lady and got married, and they blessed with 2 children, and the lady continued to live there, and she never attempted to come back to India, though she is, they requested her to come back. And now she also deserted the 2 children, and she wanted to have her own life. And this person was a little depressed by that, and he was knocking so many lawyers' doors in the city of Vijayawada. He did not find any answer. And it so happened his colleague's wife is working along with us here in the sociology department, and she said that, okay, we will have some answers, come back. And then that person has approached. By that time, he was ripped off almost a few lakh charged by the local lawyers without giving any kind of relief. So why I'm taking this particular issue is that it is a very interesting phenomena. People are not aware, but we at the VIT-AP School of Law are trying to make an attempt to disseminate the subjects of international law. Yesterday we have seen there are 3 interesting areas, like the domains of public international, like international space law, the domains of biotechnology, and other technological areas. So today we are transversing with conflict of laws when there is no clarity on the enforceable agreement and there is no clarity on jurisdictional aspects. So this is one of the interesting facets and challenges of private international law. So I'm sure students will have you will make an attempt to understand this and try to find some interest. I know all of them are, you have glued with your mobile phones and your heads are always bent and glued to your screens, but look at us, look at this auditorium dais, and listen to the people, and you will get at least some idea of what the experts are speaking. Okay, so this particular session has been primarily devised to speak with 3 important aspects, that is the influence of AI, artificial intelligence, the metaverse and blockchain, on the evolving legal doctrines of the private international law. And we are also speaking about that a need and a necessity of legal harmonization to address the digital economic disputes which are happening. And finally, we also try to look into that through this particular session, ethical and policy considerations in regulating AI-driven dispute resolutions and algorithm governance. It's a very, very topical things which we are talking. And within that, I have taken one specific topic, that is CBDCs, the central bank digital currencies. Yesterday, I mentioned a little bit in my inaugural welcome address, then how this particular central bank digital currencies are going to work, and what is the issue with that. And when you look at that, we have any of the currency notes, and we, or maybe any other promises have been executed. We always deal with under the rubric of special contracts, that's called Negotiable Instrument Act. And all the students must be aware of it, because we teach that in the first 2 semesters, and we make you to understand the basics of this. So when you look at that, today with this kind of notes, you don't have any dispute, you don't have any issue, and it's very clear, and it is already written and clear in that particular note saying that I promise to pay the sum of the so and so. And when you carry a check, the same thing, contractual obligations are there. When you demand draft, everything happens like that. And now today we also have that digital transactions within a particular jurisdictions. And when you look at that, UPI payments or Google payments, when you look at that, contractual obligations, although these contractual obligations are unilateral, one-sided, none of us are ready to read the lengthy documents of that one, but still we are following, and the clarity of the jurisdiction is very clear. When it is clear, we don't have any issue. But what happens when you are transferring the same money, or maybe when you are sending some money or maybe instruments, if the jurisdiction or maybe other points are not clear, what would be the ideal solution for that? Now today, the reserve banks, that is central banks, are trying to adopt these digital currencies. The main aim of this arguments given by the central banks is that why they are going for the digital assets and digital currencies to address the problems of the money laundering and terrorist financing. This is the idea which they give. But they have different ideologies also. That's a different thing, but that's not the point which we are trying to discuss that one. But we are only trying to look at that if this particular AI driven or blockchain technology driven digital assets have been created, and that's becoming the present and future transactions of the people to create the assets, then how are we going to look at it? Do we have any kind of legislative and regulatory mechanisms within the jurisdictions? Yes, maybe some of that central banks they have, particularly in Bahamas, Nigeria and Jamaica, and they do have. But what about other countries? They don't have. And why this Bahamas and Jamaica and Nigeria they have? They have different systems, and Bahamas is one of the places where they try to make all kinds of transactions, whether it is transactions coming from the different proceeds, all are being washed, laundered, and they have been recreated and reflushed into the markets, and maybe they will get to park in the jurisdictions where it is required to be parked. So that's how it works like that in these jurisdictions. That is why they quickly adopted that one. And this kind of money is undergoing this kind of transformation throughout the kind of things. We are moving from the metal coins to the book money to bank notes. Now we are also taking the advancement of the technology. So what could be the ideal solutions when people are encountering the problems? Now that is why the CBDC central banks must diligently consider its legal platforms and legal foundations. So because all of you must be aware of it, and all of you must should think about it. And the students, today you may not be thinking of it is not of our relevance, but at the same time, it is not our effort to make you an expert of private international in these 2 days, but at least we want to make you to understand the terminology and vocabulary of this particular subject, so that tomorrow, when in your practical life, when you are going and taking the obligations of your professional work, at least you should be informed about this kind of information. So now, during this particular discussion with the central banks and IMF staff, they have noted that there are potential issues related to the CBDCs and its issuance, and sometimes they have been overlooked in the initial design itself. Like we have yesterday spoke about that bitcoins or maybe other digital assets, and when they are transacting, and what is the legal issues and how their initial design stage, and which language model will appropriately fix them for the purpose of creating a ledger and a depository, and then facilitate them securely transferring to the other individuals. That is a one particular question which comes. The second point is that the fintech technology and fintech nodes is a part of the IMF legal department, and still they are trying to find the gaps, and they are not only understand that how this can be brought into the rubric of the legal mechanisms and inform the states so that they can have some kind of regulatory and policy level mechanisms on this. And the third issue is that now when this particular things were examined, and quite often we come to know the issues of the enforcement, or maybe having guarantees to that particular digital currencies which have been issued. And particularly these currencies, primarily it's a token based. And it is used by both retail as well as the mass scale use of the people. So when this kind of novel features are existed in the digital platforms, and it is required to be translated into binding legal obligations and liability aspects within the facets of the law. So that is why the token-based CBDCs primarily defined a kind of three important aspects, saying that when we have the form of money issued by the central banks and expressed as official monetary unit, and when the official monetary units are transferred, where the monetary claims central banks can give the guarantee, the first thing. And second thing, when the central bank is incorporated in the digital token system, and when they are equating this transfer to the transfer of the claims, then if any kind of exigencies happens, how the central bank is going to give the guarantee? Is the central bank responsible for giving the guarantee for the loss or scam or any commission of the fraud committed by the people in the third jurisdictions? How that central banks are going to deal with that? Is the central bank is responsible for giving the agreement to you like what they have given or executed under the Negotiable Instrument Act? Like as I mentioned that if you take out your physical note today and you look at that, I promise to pay the sum of money so and so. So that means you take that note and you can exchange. That is well said rules in the law under the Negotiable Instrument Act. Do we have the same clarity with regard to the transfer of these claims, and when you are equating and when you are going back and claiming the same money? And without another problem is that without current account or without any relationship between the central bank and the holder, and if any legal issues are going to happen, how are we going to bring that particular relations into the rubrics of law? So for example, when we go to bank, when you want to open, when you want to transfer, they will first ask you that whether it is your mother bank where you have the account. And once you have the account, you are regularly having the KYC. When you are regularly having the KYC updates and all kinds of checks have been followed by that traditional banks, now when you are transferring and using the digital platform, transferring the digital assets, do we require the same protocol where the central banks are going to talk about that? Now we have our the scholars and our colleagues, Dr. Abhishek, he worked on that particular subjects of law about how this kind of banking regulatory mechanisms facilitates. He can speak more on that because that is his expert areas of how these things can work into that. And coming to that, the last point is that whether it is legal rather than technological. First of all, you only look into that is a technological problem, or to create what do you call it as self-secured mechanism where there is nobody can penetrate into this kind of a system, give that full-fledged security mechanism for transfer of the system without any human intervention. Are we going to create that? But there is no such kind of a thing. So today in digital platforms, anybody can interfere, and anybody can scam, and anybody can, it is a volatile mechanism. It is just a click away. They can scam the people and they can arrest all the digital assets. That's how it is going to happen. But when it is happening, what could be the mechanisms adopted by the central banks. There is no guarantee, there is no clarity on that particular things. Even if you look at that in the Bahamas and Jamaica's regulations, we don't have any kind of clarity on that. And now that is why, since there is no clarity, no obligations, now it requires a private international law must interfere into it, and we can find some solutions on that. How are we going to find solutions on that? First thing, when we have the token-based CBDCs and we have to complement them successfully with the other forms of money, we need to have some kind of certainty when we are adopting that one. The certainty is very important. Like what we have the traditional banking system. The second one, the factor on this conclusion is that we have to connected issues like how token based CBDCs can be, especially it's going to play a role of intermediate holding structure, or maybe creating an obligations to the bank as well as receivers and the people, those who are transferring that and creating this particular assets. There are three different people who have been involved, along with that, some governmental and private agencies. And among that, we also have, it is a platform-based economy. When platforms are created by the some technological companies, what is their obligations with regard to that? So are we going to talk about that tortuous liability with regard to that third party, those who are creating the platforms for this platform economy? And these issues are not clear. So hence, in the midst of all this problematic issues, so what the proposal which I am trying to argue in this particular paper is, we must have a private international mechanism where all these rules have to be boil down to one particular draft uniform legislations, and if we can provide that one, that is a good opportunity to transform the physical monetary system to the digital monetary systems. I think with this I will stop it here, and thank you very much, and I wish all of you will take some of important aspects of this in future course of discussions. Thank you so much.
Thank you very much, sir, for throwing clarity on the enforcement agreements in CBDC and various other issues relating to money laundering, digital assets, and giving solutions regarding the same. May I now take a minute to welcome Professor C. Gerard, sir, a renowned academician in international law and a wonderful father to a dear friend of mine, Akhila.
Good morning to all of you. First of all, I am very grateful for being invited here by my very good friend, Dr. Chaka Banerjee. And I find that this university, the law faculty, is also having a compulsory 3-credit course on private, 4-credit course on private international law. So I think this is the right, school of law to start discussing about the private international issues. And I have not come with any grand theory on anything, but just some random thoughts I have. By the virtue of the fact that, they have given a very solid and, challenging combination of themes, private international law in the era of new emerging technologies, and the way forward. It is two things together, that is private international law and the technological impact on this. And just now in his paper, he very effectively articulated one aspect of the digital asset, and that showed you all how difficult it is to even comprehend the legal issues about these digital assets and all that. So this is how. But then I would begin by saying that there are two difficult subjects. That is, it is not that the technology is very difficult to comprehend, but even the private international law is very difficult to comprehend, because it is not one of those regular subjects that is spoken by politicians like environmental law, environmental degradation, or climate justice, climate law, or by the policymakers, legal advisors, and human rights. It is not like that. This is one of the most esoteric subject which is not actually taught as a main course in almost all the universities here or law faculties. So the second one is the technology, the complications. So it is very difficult to make a combination of these things, but it is happening. And it is happening in a way that we are forced to now discuss about what are the private international law questions that are to be addressed here. Now I will say about how private international law is viewed historically by even experts, even judges, how difficult it is a subject. That is that one of the very famous great American judges called Benjamin Cardozo. You must have heard about him. He wrote the book called Judicial Process. He said once, the subject of conflict of laws or private international is one of the most baffling subjects of legal science. And observed that the average judge, when confronted with a problem in conflict of law, feels almost completely lost and like a drowning man will grasp at a straw. Now, this explains the example given by Dr. Banerjee about somebody in England who came and we could not get a lawyer to advise on an issue. And it is very difficult to get lawyers to deal with these matters. It is more difficult for a judge actually to handle the matter and give a judgment. So it is definitely a very complicated, baffling subject. There is another episode I will tell you to again emphasize on the difficulties in approaching this subject. That is one Chinese judge called Judge Lee. He retired at the age of 90 from International Criminal Tribunal for Yugoslavia. The retired age was 90. He retired after nearly from the day one it was established, and he retired. And there was a farewell party, and people asked him, "What are you going to do now?" He said, "Look, I'm thinking of now writing a book on private international law." They said that, "How at this age, what will you do?" He said, "I think this is the age where I will understand it." So it is so difficult. And I myself say that in 1976, I studied one full year course, private international law. And Dr. Gandhi was also product of that faculty, Madras University. So therefore, after that, I had some interaction at Indian Society of International Law. And after that, now I'm, handling certain things. It is, I can say that it is not easy to grasp, and then nothing is in your fingertips in private international law. Every time you have to refer to the case laws, refer to the, the fundamentals. Now, but the fundamentals were actually for yesterday, at least 2-3, our friends, deliberated upon the fundamentals, that the building blocks of private international law, that you heard about, jurisdiction, choice of law, what is the classification of the nature of the case, connecting factors, and then engage this enforcement and all that. So these are the fundamental features of private international law. Now, when shipping technology came and navigation began, there followed a law on navigation, national and international. When the aviation technology came up, there were national legislation to regulate that, air navigation, and then also international convention, ICAO. And even you take the nuclear issue, when the nuclear science developed into, making bombs or even otherwise, there is regulations on civil liability on nuclear possession and stockpiling nuclear things. And also now there is a convention that has come, but very few countries have actually ratified that, the convention prohibiting the even stockpiling and possession of nuclear weapons. So what I'm trying to say is that as a technology emerges, applied it to practical side, and it becomes the use becomes a critical mass, then there is a necessity to legally regulate for proper allocation of competences such as rights, duties, breaches, liability for breaches, and then dispute settlement mechanism. So therefore, it is not the for the last 5-6 years that we are challenged by technology. Technology has actually been the forerunner of even economy, law, and even some social conditions after the Industrial Revolution. So you can take the technology actually leads, but it is not a people's subject. It is not a legislator's subject. But then that is how even today, I would say, whatever may be the technology that impacts on a legal system or it compels invention of a new legal system, as far as the private international law is concerned, the structural blocks of jurisdiction, this choice of law, party autonomy, and then connecting factors, and then judgment, these are the fundamental features. It will never change. Technology keep changing, but this private international law building blocks will hold the field for maybe quite a few centuries from now, because there is no technology to change it. For example, the ideas of private international law, doctrines keep changing, or legal positions. For example, earlier, the nationality of a woman, it was said even in everywhere, that it follows that of husband. But today it is not like that. It is a woman has her own domicile independent of the husband's this thing. That's a legal development. That's a social development reflected in the law. But same way, the technology also compels us to innovate legal doctrines and concepts. But at the same time, the fundamentals don't change, because that is a basic structure of the legal system. With that, I will say about something about artificial intelligence and the Bitcoin and cryptocurrencies. You see, now yesterday onwards, we have been speaking about this thing. Now, what is this blockchain? Blockchain is actually, it says that decentralized, distributed, and immutable digital ledger used to record transactions across a network of companies or nodes. Technology underpinning the blockchain is known as the distributed ledger technology. This is a basic future of the blockchain. That is, now you compare this blockchain technology of distributed ledger technology with what Dr. Banerjee told about the central bank regulations relating to banking. That is, you have to have a permanent ledger, records, and all that. They are all visible, they are physical. It is easy to produce in evidence in court of law if there is a trial. But here, this is decentralized, anonymous, and it is across national jurisdictions, and it is also said that it is everywhere, but it is nowhere. But when the digital assets are everywhere and nowhere, how will you fix which jurisdiction will be the jurisdiction to deal with this matter? Whose law will be applicable? And how to find out when it is invisible and it is thousands and maybe millions of nodes. Okay, a node means only a computer. But then this blockchain has got the same information in all computers. That is one aspect of it, that they say it gives clarity to those people who are having the digital assets in that. But now, so how do we find out the exact law, this thing? And now you know that how it is, the basic thing is decentralized. Then immutability. It says that once data is put in the blockchain, it is immutable. But I cannot say either artificial intelligence or blockchain technology or any technology that is foolproof. There is nothing like that. Even science is a verifiable one. Science, what is science today, is not science tomorrow, because there is a more advancement. So I am not sure. For example, AI, it is the Supreme Court of India has been repeatedly warning that resort to AI by lawyers is very dangerous, because the AI gives you 70% of the information collected at the pressing of a button, but the rest of the 30 it doesn't give. That is there even in medical world, in a health sector, that you go there, there is a this thing, scan and all that, and within those days it takes together. But today when you come out, they give you the thing, because it takes you to the very closest level of the fact. If a disease is actually to be diagnosed, it takes very close to the diagnosis, but not exactly the diagnosis. So there is an opportunity for a doctor to conclude this is the diagnosis, but without the actual diagnosis. There is a issue of medical negligence. And then who will be responsible for that? All these issues are coming in applying technology, at least during the formative years. But whenever a new technology comes, it has to stabilize itself, not to create vacuums and loopholes in that. You see, these blockchain applications are applied to cryptocurrencies like Bitcoin and Ethereum. Then you see that, if you send a courier from Berlin to this place, Vijayawada, then you given a number and then you track it. That delivery system, all are actually in the a blockchain is used in that one. Now, in a very interesting thing in India, in the land records, the land records all over India has been traditionally on the books and the documents and then physical forms. Now about 8 or 9 countries in our country have used the blockchain technology to record the entire millions and millions of title deeds into computer system using this blockchain technology. Now you just ask for a change of title, that is colloquially called patta. It doesn't take time. It is just, you see there, they change the name and you get it. So that technology is not used only in currency matters, but it is also used in governing, it's part of the governing system now. There is a document by Tamil Nadu government, this policy on using the artificial intelligence and blockchain. There is a full document on that. It's available in the internet. So therefore, it's used. But then they are also not legal tenders. These cryptocurrencies are not legal tenders in a physical term, but they are considered to be sometimes. They also come before the courts, and the courts are actually able to handle the matters. Whichever dispute arises out of cryptocurrencies, whatever is the dispute, irrespective of the decentralization, anonymity, invisibility, hidden aspect and all that, courts are able to identify the real issue, identify the applicable law, which I'll demonstrate to you. But what is happening in Europe? Europe is the place that is happening place about private international law. Now, Europe has got a very good crop of private international lawyers. And now the governments are also very active there. You have several countries have made legislations on this thing, including US, that uniform, commercial code has got a chapter on these things. And then there are countries like, Netherlands, Germany, Spain, Portugal, they all have made legislations on that. But the difference between Europe and the rest of the Europe is that the Europe is a civil law countries. There you have to have the law on everything. The case laws are not taken as a basis for legal action. But in common law countries, there are all the countries that follow the common law system. The judges are able to assume jurisdiction based on certain factors, certain links and all that, but they are able to even apply a law that is proper to that dispute. Because the common law judiciaries are actually equity jurisdiction. They have what is known as equity jurisdiction, and they can assume jurisdiction on that one. Now, that's how they actually are going about it. Now there are other. Yesterday you had a lot of discussion by Professor Stelina Joly on these smart contracts. She articulated very well. But then there is an associated thing with the smart contract. That is a collective of smart contracts, what are known as the decentralized autonomous organizations. And that is more difficult to handle than a mere smart contract. That is more challenging. But I will not, deal much about it now, because each one is meant for solid, deep-rooted research and the production of documents. Now, there are people who say that how to establish yesterday I think Professor Hegde was addressing the issue of real and effective link of the law and the matter in hand. But I thought that that is also similar to something called a genuine link. You see, there is no link, there is no connecting link to find out the applicable law. But there is actually something like genuine link in international law to establish the nationality. It was in a famous case, 1955, called Nottebohm case. But similarly, I think even the European lawyers, the civil law lawyers, but the mainstream European lawyers are arguing, we have to actually find out what is the new connecting factors. Because of the new developments in technology interface with private international law, are there any new connecting factors? Now, first time, the building blocks of traditional blocks, that is the connecting factor, how to have connection, that criteria is being sought to be changed, but they have not yet come with the clear idea. Even those experts who are professors, and I have seen a lot of literature on that. But one of the professors who says very well, and it's all much ado about nothing. One French professor says it is much ado about nothing. But that I can prove what he says is true when it comes to countries like England, India, Singapore, and other places. Whatever may be the difficulties, for example, the habitual residence or seat of a person or entity that has some power of administration of the decentralized autonomous organization, or the place of the incorporation of the incorporated DAO, the registered address. See, even the civil law countries people are giving 5 or 6 new criteria to have connecting links. That means that even the traditional belief of civil law countries that only statute-based application is no more possible. Either they have to keep creating legislations at every turn and twist, or they lose the judiciary's application of law to a justice. So that is how this expertise opinion is coming out of Europe. Now, let me say about something about this, how the common law countries actually have done this one. The question of digital assets. Are they a legal category? Are they actually a legal tender, like he said that I promise to pay you? Is there anything like that? There is nothing like that. So one case first time came for the debate, and that in the case, it was English courts decided that they are also assets. They are also property. The property that can be stocked, that can be exchange, that can be restitution can apply to that property. So first time it is accepted in England by the High Court of England and Wales that all digital assets are actually properties. Like it is irrespective of whether it is tangible or intangible, that is a property. So that's the third kind of property they have accepted judicially. And that is what is being followed in other common law countries. In India, the Supreme Court about, I think, 2023 settled the matter in one case, which I forget now, that cryptocurrencies are assets. They are property. They are subject to income tax and capital gains, levy. So that means that all the cryptocurrencies in India are actually legal tender, and irrespective of the format in which is available, they are subject to income tax and capital gains act. But we do not know how the income tax department will find out who has what stock of bitcoins or other cryptocurrencies. That is their business. But law has already arrived to treat them as an income or an asset and a property. Now, recently, having seen the UK's courts, repeatedly saying this is a form of property, the UK, there is a law they made in actually October or November 2025 that it's called UK Property Digital Assets Act, which recognizes officially the digital assets including cryptocurrencies, non-fungible tokens, and digital files as personal property. In other words, I said that a third kind of property they have created. So it is now from case law, common law, it has become a statutory law in England. But in India, we don't have a statutory law to handle all those things. In any case, to provide the rules of private international law to deal with all these matters. It is actually emerging. But let me say about a very interesting case about, that happened recently in Madras High Court. A very interesting case. Case is called Rutu Kumari versus Zanmai Labs Private Limited. It delivered a judgment recognizing cryptocurrencies as property. It is attributed that it is a landmark jurisprudential progress in our private international law field. The very interesting facts are there. One system was subject to cyber attack, especially targeting certain cold wallets holding varying ERC tokens of value greater than $230 million. That operator, WazirX, through its Indian operator, Zenmai Labs, then froze numerous user accounts and proposed a rebalancing scheme. That is, yesterday we heard about Sridhar's address on the insolvency matters, pooling together of the assets and redistribution equitably through the insolvency and restructuring proceeding instituted by Zenmai's parent entity, ZETI, before the Singapore High Court. This petitioner in Chennai seeking approval of a scheme arrangement. That ZETI has also been pursuing arbitral proceedings in Singapore in relation to WazirX users contesting the restructuring scheme. I have shortened this thing, but it's a very complex web of facts actually, and you have to read that to get an idea. But the petitioner before the Madras High Court, having purchased the XRP coins on WazirX, that's the operator, sought injunctive relief under Section 9 of the Arbitration and Conciliation Act 1996 against the Singapore arbitral order to prevent Zenmai and its directors from redistributing, that is, pooling and going ahead for insolvency. That redistributing or reallocating her specific holding, that is, her own share is also being taken for pooling purposes. Then, which was not in her thing was not involved in the cyber attack, but it was in the holding of the operator. But then yet the operator, he decided to freeze including hers and then redistribute it. So the Zenmai disclaimed liability itself as saying that it's only a distributor of rupee to crypto transactions and that foreign entities are controlling the actual wallet. So now you can see how the defendant in this case is arguing that I am not controlling, it is some other wallet is controlled by somebody else. How a judge in Madras High Court will be able to, have the chain, the links in the chain for evidence to establish who is liable and who is not liable. Now, anyway, after all this hearing both sides, the court said that, raised the issues for consideration, whether the applicant's cryptocurrency holdings can be considered assets situated in India. Now it is Lexus Citus. Where is the asset situated? That is there in blockchain, whether it can be considered because the petitioner is in India. That is one question for consideration for the purposes of establishing jurisdiction. Now, yesterday our Professor Rajalakshmi said that Lexus Citus extractus. In fact, she brought a very beautiful, idea of each technological world creates its own legal sense. That is how it came up yesterday. That is where the biological resources are extracted. That law should be applicable to private international law disputes. Yesterday she coined that very inspiring concept, Lex Citus Extractus. So here it is whether the Lex Citus can be applied. Now, whether the proceedings before Singapore High Court resulting in the modified scheme arrangement will bind the petitioner. That is, the Singapore High Court proceedings will bind the petitioner in Chennai. Now, anyway, the court finally held that cryptocurrencies, virtual digital assets, VDAs, qualify as property under Indian law. The court stated, it is not tangible property, nor it is a currency. It's a property which is capable of being enjoyed and possessed in a beneficial form. It is capable of being held in trust. This is the Indian law treats cryptocurrency not as a speculative transaction, but a virtual digital asset under Section 247A of Income Tax 1961, and that the investment by the petitioner was converted into cryptocurrency, which is capable of being stored, traded, and sold. The freeze on the operations on the assets under custody does not allow for the erosion of the assets themselves. Zanmai has a fiduciary obligation as a custodian of the petitioner's asset. Now, I read out about this case precisely because you can see it is not that there is no law which can handle any issue that comes before a court, the foreign element with a cryptocurrency or Bitcoin issues. There is a way of handling these issues to render justice. And that Madras High Court judgment very clearly demonstrates that the private international, as it is now, can be applied to the existing technology aspects. Now, I will end up here by saying at the last thing, what is the way forward? Now, everybody is suggesting there is no clarity, very few people read the private international law, and say, no, I would like to suggest something, because you see, the technical subject on private international law is always a boring subject. That is one reason why many people don't pursue this matter. But there are people like Venkatachala Hegde, who is very curious about every branch of international law. So there is no problem about it. But by and large, it is baffling, and that aspect discourages many people. So I would suggest at the end of, to end my presentation, that it is supposed to be, the cryptocurrency is supposed to be a market capitalization of $1 trillion today. So we have proved that in common law countries, there is no need even for a statutory law. It can be handled. It has been handled, no problem. But is it the solution for that? Only courts in India will be handling private international matters after after decades of independence, we are not able to even draft a model law on private international law, conflict of rules, what they are applicable. I have got collection of books from the erstwhile Soviet countries, the private international statute of most of those countries. There it is a written down law, including labor law. When a labor goes from India to Soviet Union to work, what private international law applicable, it is there. So we are not able to produce that kind. But should we observe that yes, there is nothing in this place, but should we leave it at that? Then what is the use of this, an expert body? We have to make it. So, but I suggest that we will be able to form, like I echo what Professor Banerjee said, to take it further. I think we need to establish a committee of volunteer experts in this. Bankers, central bankers, private bankers, those banks that actually deal in cryptocurrency, and then private law firms, and then committed academics. Like we are all committed to promote the paradigm of private international law. We should form a committee, and the committee should go by analyzing the global trends, the civil law countries, common law countries, the American Commercial Code, and then the help of the hundreds and hundreds of private international law cases, or actually case laws are there in India, Supreme Court and various high courts. If we can make certain rules on the fundamentals, then it is not difficult for us to make the draft rules for to handle this subject. That is the interface between technology and private international law. I think it's only hesitation to do it, and how many of you are willing to do it? This question will remain forever unless somebody actually takes up the matter. I leave it to the joint organizers of the VIT-AP School of Law, which is so enthusiastic, and the Indian Society of International Law. The executive president is here, the vice president is here, and then there are other members of executive council are here. If they can agree for a joint project on looking into technology and private international law, I assure you, I will give my best efforts to that one. But of course, it will not be an individual responsibility. We have to form a group, a working group, to produce a conflict law rules on technology impact on private international law. This is my suggestion, because I don't want to go without a suggestion in the context. And as far as I am concerned, I am going to continue the study on my own. If there is any anybody who is interested in joining me, they are most welcome to join me in exploring the matter further. Thank you so much.
Thank you very much, sir, for the wonderful keynote address. In fact, it has enlightened all of us, and we've duly noted your suggestion also for establishing a working group. So that is quite enlightening for us, and it is going to inspire most of us. I'm sure most of the faculty are also enthusiastic in contributing towards this. So we now move forward for the paper presentation. Before that, I would urge the students to please stand up for a second. All of you, please stand up. Sit down. Please stand up once again. Sit down. Because of the inactive participation and concentration, we just wanted to wake you up. Indeed, sir. We'll move forward to the paper presentation. Due to paucity of time, I request the paper presenters to kindly limit their presentation for 5 to 7 minutes. We have 3 paper presentations today. starting with Dr. Abhishek Tomandru. So I request Shravya to introduce the keynote speakers. Sorry, paper presenters.
We will now move to the paper presentation segment. I now invite our first presenter, Professor Dr. Abhishek Tomandru from Alliance University on reimagining jurisdiction in private international law, autonomous AI agents, quantum resistant smart contracts, and multi-jurisdictional data sovereign conflicts.
A very warm. Okay. Sure. Yeah, apologies for that. A very warm welcome to the dignitaries here and the panel members and the VSL conference organizers and my dear students. Before I begin, I want to thank Banerjee Chakkar sir for giving this opportunity, because this is the second time I'm standing here, because I'm also an ex-alumni here. Technically, I'm the first scholar of VSL. So, and subsequently, I'm getting an opportunity speaking as a speaker after a period of time. So, I have seen gestures that looking at my title, that's very ambitious and ambiguous in all aspects of life. But for finalizing the theme of the session as well as the scope of the conference, the area was grounding towards the immediate principles. As I've seen, our keynote speakers have already set the tone and giving the very much insights which I have already interpreted in my paper, but I would like to give very much fractional insights and the paucity of time. So, yes. So looking at the spectrum, how do we decide jurisdiction when decisions were made just by humans? So, but by artificial intelligence, blockchains, as the speakers has mentioned, cross-border networks and scenarios. So as Gerard sir has mentioned, in private international law, place of contracts plays a pivotal role, and the location of incident happened as a harm, subsequently the residence of parties. This is the law we have tend to see in terms of any conflicts and issues arose. But how do we ascertain if this is done in digital version? Because nowadays the deeper reliance on the technologies, specifically the autonomous technologies, which will make the life easier, that's what we deem to believe. Since starting from academics, there's several tools have come into picture. That high likely the two set of tools we get to know what is no code tools and code tools. So high likely students and teachers and professionals, anyone like us, to ease our business and activities, we're using these no code tools. But while reliance on these such kind of tools, what is the prevalence of any issue arises? Who shall be the liable person, and where shall we seek the resistance of finding the cause and also asking for any kind of compensation of such liability or harm happen? So my paper is trying to focus on three aspects. One is, what is the role of human residence towards any aspects happen in terms of autonomous activity? And if in absence of such, do we need any kind of self-regulatory role towards execution of those codes? And subsequently, when these transactions or the data is being transferred from between two different regions, what is the scenario of those data fluidity? Who owns the data? Generally, when we teach laws, we specifically go down towards the principles of grounding, that wherever things happen, that place is a residing of conflict as well as jurisdiction. But does the data have any jurisdiction? Because the question comes, where does the core problem stagnates? Imagine an AI trading by a bot, which you guys design. Subsequently, it transacts in Singapore, but you reside in India, but the transactions is flowing from UAE bank. But where does the data flow? And subsequently, when executing these kind of transactions, specifically in blockchain or any other pattern of platform, who owns it? Because which country has jurisdiction is the biggest question these days now arose. Imagine if something goes wrong, and if fraud happens, a loss happens, something cheats, what is the central problem? Because law is territorial, but technology is boundaryless. So imagine this is the scenario of this, how can we expand the granularity towards having a betterment of segment of laws? So as seeing that, my paper is trying to fragment on three aspects. One, how do we create a jurisdictional fragmentation, and how do you map territorially in terms of cross-border, international borders, having, despite, as Gerard sir mentioned, having common law pattern and civil law pattern. Looking at those gaps, how do we enforce those kind of patterns for better enablement towards it? For example, a developer was in the US and the hospitals are in India, and the AI model was trained in European Union data. Because looking at these three different regions, if any technical glitch happens or something lapses, or any hospital has not able to function properly, who is responsible in this such scenario? Because as we know, our traditional knowledge or traditional law applies based on the human action and the territorial aspect. But the solution is the paper is trying to provide is known as hybrid AI agency. So what I'm trying to provide is that AI is fully not independent. It relies on developers, developing systems, and users. So how can we find a better new jurisdictional factors which when state cannot provide in terms of Gen Z, and also to grab your attention for a second. So imagine if this is a scenario in the near future. As you can see, the judge is asking who signed the contract. So as we have autonomous contracts by a bot replacing on your presence with your consent, it says I am the one who has made a contract. Subsequently, then who are you? The judge asks. Were you a legal person? Were you a representative of a legal person? Or you are a person who are not at all a person? So then the AI's response depends on jurisdiction. So you can easily, AI is not just an artificial intelligence. It is also going on self-learning, reinforcement-based learning decisions. It means that high likely the AI does not have a conscious, but it has a mere sense of replication of human abilities which humans are tend to do. So in those scenarios, if we ask something to anyone, high likely we may say truth or false, or you may lie in some instances. But same thing if the developers, the one who develops the bot or AI, ideologically he represents his image of thoughts in the same software itself. So if that software is high likely to do an error like hallucination in your instances, what is the scenario if it's been questioned by the court of law? So this kind of imaginary perspective towards is been granted towards the system. So this is the exemplary ways where data is stored, how contract is fundamentally questioned, and the fidelity towards the data flow is being very vibrantly discussed in the image of explanation. So these are the proposed framework which my paper tends to focus on, because as you can see, there are three structures. One is deployment state and jurisdiction and data control and system control. So what are these trying to focus is that when AI is designed, where the AI operates, where the AI data comes from. But technically, this is a kind of a major shift towards geography, towards control-based jurisdiction. Technically, I'll give an instance in our homes itself. You have parents, mother, father, and subsequently your sibling, your elder brother, younger sister. So if I ask who is your head of the family, high likely you can presume to say father is one. Some families may tend to say mother based on the family system, as we have the Abhagam Taksha system. Subsequently, if this kind of ideology has been adopted in terms of AI, so technically the grounding principle of jurisdiction comes where data resides. This is the high likely first principle where there's a gap is propounded to resembling the humanistic approach towards AI-based mechanism of finding a jurisdiction approach. So this is what we're trying to provide, a conceptually framework towards similarizing towards what already existing in the traditional laws. So in terms of going further, these are the other principles which we're trying to focus on terms of contracts. As we all know, everybody uses Zomato and Swiggy, right? Imagine that suddenly you wanted to be so busy in your daily life in teacher assignments or office works and you don't want to automate things. So unknowingly you install a bot or something in a device which will help you to order when you feel hungry, which you are assessed towards your smartwatch. So whenever your pulse is weakening and suddenly you get a sense of low palpitation or towards a low blood pressure or something, the BP or something, suddenly your device will alert the Swiggy app. It's a futuristic approach. That is, an app will automatically order your favorite dish. So high likely you're not aware that these things have happened, but until unless the day minute you see your balance has been deducted for subsequent transaction. So if this is the scenarios, what are the grounding principles? I'll wrap in 2 minutes. So what are the grounding principles of existing law and cases towards those layering of cryptographic control? So what I'm trying to propound is that the problem arose from time to time, zone to zone, and the place to place, but the challenging conflict is that when the data sovereignty or the data flow has been binding on those terms, what is the aspect of towards solving and resolving the disputes? So we need large global data set and subsequently cross-border data set regulation in cross-jurisdictional aspects. So what the final proposition is I am trying to provide in terms of private international law. With this concept and futuristic approach, we may high likely the law must evolve with technology and to endorse, but not resist it. That is what I am trying to focus. Before I conclude, as this panel has already suggested, we are in the terms of CBDC transactions. But one example I would like to quote where the quantum resistant transactions are used in. One example in China, we have known as place of Shenzhen, where people are transacting based on your hand wave and your face payments. So we are still at the nascent stage that what is the implications of those repercussions of those market players inducing those technology features. We are still discussing at the position of CBDC and those stages of transactions. So the new emergings are more new emerging. It's more advanced, self-resisting and advancing technologies. So with this is the proponent of conclusion I would like to towards that when entering a world where machines act, code enforce agreements, data defines power. My final thought is that if law does not adapt to technology, it becomes irrelevant. So therefore, I conclude my presentation on this. Thank you for your time.
Thank you, sir, for your presentation. Next, I invite Professor Vadam ma'am from Assistant Professor, Alliance University School of Law, to kindly present her paper on resisting digital colonialism, balancing privacy and data protection through state and non-state actor obligations.
A very warm good morning to one and all present here. It is even and equally nostalgic for me, likewise for my pre-presenter, being a second scholar of VSL. So, this is the area where I started my research, and this is the playground where I started playing with this subject essentially. So it is therefore very nostalgic for me to present, especially before Chakka sir. Let me try and put my views with what I have learned from him all these years. So this research has built context from where the private and public law emerges. Over the time in technological sphere, we saw that wherever the public law had loopholes, it was the private players who has tried to overlap. And we saw that the private and public sphere therefore was always merging when we started talking about privacy and data protection per se. So that made me brought to this topic about digital colonialism, where I saw that they are mining our data, they're exploiting our labor, they suppress your voices by the act of philanthropy. So I divided this research using 5 case studies. Now, to begin with, for the case studies, I researched at the Swiss Institute of Comparative Law, why is there a universal lack in recognition of data privacy and protection principles globally? And similar was seconded by a lot of my co-chairs who said that there is a lack of recognition of these global principles when we talk of technology. So I read and I researched why Christopher Kuhner, Graham Greenleaf, and Daniel Solve and many authors who seconded my opinion that yes, there is a lack not in just point of law or recognition of global data protection principles, but also a political will. Then I read Chinmay, Arun and many other authors who also seconded my opinion or finding by saying that it is the technological companies who are evolving with a self-regulatory mechanism, and they are in a sense lobbying what we saw during the presence of EU AI Act. to create that lack of political will to create a global recognition on data protection and privacy principles. The same was though recognized as in the Hague Conference and many such other private international law forums held by United Nations at some time, which led to recognition that there was a need, there was a demand of such recognition, but the same is not yet fulfilled. So this brings me to the topic of digital colonialism. I did a thorough research on how digital colonialism is defined per se, and I led to the definition which was given by the second proponent, that is Scholldry and Magis in 2019, which talked about that the definition said that it is the process in which the government and non-government organizations and corporations claim their ownership over private data that is produced by their users and citizens. Now, to establish this per se, I use these 5 case studies, and let me take you through them. The first one is when in 2015, Mark Zuckerberg came to India in the village of Chandauli. And what it showed as a philanthropic act of free basic being introduced to India, and it was the first time when free internet was being therefore given to Indian citizens, there was after a period of time, there was a lot of callback over it, that this is leading to a sense of digital colonialism. And how? Because when you are using free basic, you can only go to the websites that Facebook wants you to go to. So you have a free internet per se, but you do not have that freedom actually in reality or in infrastructurally if we talk of. Very similarly, therefore, when I read many other authors, as I quoted, they said that even if data is incorporeal in nature, what especially laws around the world are doing is they are trying to regulate data by what it does, not by how it works. And this is where the gap arises. And the same was seconded by Christopher Kunner in his book on extraterritoriality of data, in which he says that how global US-based legislations like US Speech Act and Cloud Act or GDPR leads to extraterritorial nature of data protection and data privacy. So infrastructurally, when I took the example of therefore free basic. The second case study that I took was how during the Arab Spring, CIA-led organizations like In-Q-Tel, which felt like liberalization movement per se, but was an act of surveillance in that country. And very similar things were seen in Asia very recently when we saw the democracy disruption in Nepal or Bangladesh or Sri Lanka. Very recently, we saw that yes, there was capture of social media groups through which it was established that how these companies are trying to manipulate the citizens, and therefore large level of surveillance was taking place, and how an opinion of one country was therefore put forth on the global south or the Asian nations to create a demographic disruption to the extent. So it tried to prove that how infrastructure loopholes or how the basic premise that you give so much power to these companies which are established in the global north per se. We should not forget that these companies are established in the global north per se. So giving so much democratic power to them to disrupt our country's democracy is therefore I saw a very big problem per se. So these were some of the posts that I saw, which can also second that how companies established in US were creating these surveillance and manipulation, psychological manipulations in countries in global south. This takes me to my third case study, that is how there is political and regulatory capture. When we talk of EU AI Act or GDPR or the Cloud Act in USA or the Speech Act in USA, we can see that all these legislations over the time has created a lot of pressure on global south or the developing and the underdeveloped nation to come up with a privacy and data protection law in a very small period of time. Although some of the countries like India took its time of a decade or so to come up with its legislation, but it still lacks in lot of fronts. So I say that therefore the global north tries to therefore politically and also regulatory capture the pressure on the global south. The fourth case study that I took is of the labor and knowledge asymmetry, where I say that how 74% of cobalt in the world, which is most essential fundamental particle that plays role in creating of these technologies, come from a South African nation, and what we give them in return. So a simple news article talked about how Facebook extracts around $9 per person from South Africa, whereas returns only $0.99 investment in South Africa in return. So we saw that there is a knowledge and labor asymmetry also, not in terms of the bottommost people who are the laborers, but also if we say there's the top and the best engineers in the global south countries are all the voice of the global north companies like Meta and Google and Microsoft and many other. And the same is being reflected by Chinmay in her article when she says there's therefore establishment of transnational legal order that is being created by these companies through a self-regulatory mechanism. So the fifth study therefore I took was of the cultural and social hegemony, which also establishes the infrastructure and control gatekeeping. And this also very recently, the Human Rights Watchdog has also given its report how Palestine voices were suppressed on social media. So all this therefore tries to establish through these 5 case studies, I try to establish that how through all aspects it is trying to digitally colonize us. And therefore a lot of authors say that colonization just left us through the doors only to come by windows. Now you can interpret your meaning of windows differently. Therefore, because of paucity of time, I'll quickly go back to the conclusion and the legal gaps that I figured it out in this research paper. That yes, there is extraterritoriality, and I read a lot of cases like Richardson versus Facebook and Australian Information Commission versus Facebook, in which Facebook just played its role by saying that, for example, in Richardson versus Facebook, it said that, oh no, you have made wrong party in the case. It is not Facebook Ireland, it is not Facebook UK, nor it is Facebook INC. So then who is the party in the case? And it took 10 long years just to decide who is the opponent against that very person. Both the cases, Chief Information Commissioner and Richardson versus Facebook, reflected a same issue in different jurisdictions in this world. So therefore, the extraterritoriality crisis that exists in data privacy and data protection. Secondly, both the cases therefore reflect how private international law or the private law has therefore not able to provide us adequate solution in that particular case. And therefore there is enforcement issue that exists. Now therefore, what are the gaps? When I studied the global data privacy governance and international data governance, I figured it out that except Convention 108 and Convention 108 plus, there is no global treaty. And sadly and very pertinently, the Convention 108 plus is none of the global south countries are member to the treaty, and it is only South African nations which are just observer to this treaty, not even a member. And therefore, I don't know how to call it as a global recognition, therefore, of data governance and privacy principles. And therefore, lastly, the fragmented authority, which over the time, I think different speakers here have talked about the fragmented authority that exists in technology per se. So this brings me to the solution and conclusion, therefore, that indeed there is a need for global recognition of data privacy and protection principles, except the UDHR and ICCPIL, which recognize privacy as a fundamental human right. but therefore it could be done through fiduciary responsibilities, ISO standardization in a form of soft law in which we will not make any law, any private international law component, but through ISO standards we can ensure that privacy is recognized by design and by default, and therefore of course through reformed governance and at the end universal recognition of privacy principles. So this brings me to the conclusion, if I can reach, to say that yes, it was indeed a Barlow's world in which we talked about free internet around the world, but over the time we have realized that we have reached Orwell's surveillance of 1984, and therefore I would say that data colonialism was not, it was a choice that we have made and given it to ourselves. And it is not inevitable per se in nature. Therefore, success will be only viewed from cannot be viewed from jurisdictional lenses. And there are a lot of discussions on global risk in which one of the authors says how there are issues which nation itself cannot resolve in today's time. Individually, and therefore there are global risk groups that are being created. Henceforth, jurisdiction, it is only through global lens rather than local lens one can resolve this issue. Thank you so much.
Thank you, ma'am. Now we will, due to paucity of time, we cannot take up the third presentation. So now we will conclude the presentations. And I request Dean Sir to share few words.
Thank you very much. I will not take much time. And Rajashri, can you just share that slide, which I want to just say a few words. And I take the students to please get up and pay the respect to this, our experts of public in private international law. One, Professor Dr. V.C. Govindraj sir, he is no more with us, but his contribution was wonderful, and we used to grow and listen to him. His wonderful and vivacious expertise of international law, private international law. The second individual we have, Professor Lakshmi Jambalkar. She is now strong and growing stronger, and she's very much contributed, lovely person, and she continued to send good morning message to all of us, the fraternity of international law people, and she's one of the greatest teachers of private international law from the ICPIL. Now we have another Dr. Gerard sir, who has taken forward the discipline of private international law from the ICPIL, and at this occasion we want to remember and pay our respects to all these people for their lifelong contribution to the private international law along with our ICPIL members, and I take this liberty. Thank you very much. Once again, we will give a long ovation to them. Thank you very much. Yeah.
I now request our respected conference convener, Dr. Benshaw sir, to kindly come on to the stage for the felicitation. Now I request our respected session moderator, Professor Amrita Gulshan ma'am, to kindly deliver the closing remarks and vote of thanks.
I would like to thank all the keynote speakers, all the paper presenters for their wonderful insights. I would like to thank everyone, all the student coordinators for this technical session to be extremely successful. We now break for high tea for 10 minutes and then we'll come back in another 10 minutes, right? So this comes to a conclusion of first technical session.
Law in the era of new emerging technologies, issues, challenges, and the way forward, conducted by VIT-AP in collaboration with Indian Society of International Law. For this session, we have two keynote speakers, Advocate Sri Saju Jacob, Supreme Court of India, Executive Committee Member in Indian Society of International Law, New Delhi, and Professor Dr. Kondaya Jonalgodda, Professor of Law, Maharashtra National Law University. I request the dignitaries, along with our session moderator, Assistant Professor Kshama Pandey Garu of VSL, to please come on to the dais. I now take the privilege to introduce you all. Our moderator for the session, Kshama Pandey Garu, is currently Assistant Professor at VIT-AP School of Law. Graduating from Banaras Hindu University, ma'am completed her Masters from NLIU, Bhopal. I now request ma'am to please take the session forward.
Thank you, Monica, for my introduction. Good afternoon to everyone. After successful completion of session 1, 2, 3, 4, we are finally starting 5th technical session of the International Conference on Private International Law. For this session, we are privileged to have Advocate and Solicitor Saju Jacob, sir, who is also Professor of Practice and expert in Private International Law. I feel honored to introduce Sir to the gathering. Sir was born in Ernakulam district, Kerala. Sir has completed his legal career in 1990 by undertaking his first practice and training at the Law Office of Advocate Isaac Thomas in Kerala and later moved to Delhi, where he worked under the mentorship of the eminent advocate Lily Thomas. He is an Indian international lawyer with 34 years of experience with offices in India, Europe, and UK. He is heading the office of Advocate Lily Thomas in Delhi. He is a professor of practice in law, a frequent writer, a speaker on international law in Europe as well as in India. He is a graduate and postgraduate diploma holder in German language. He is an expert in private international law and international arbitration. He is registered with Bar Council of Germany, a member of German Arbitration Institute, member of Law Society of England and Wales, an executive member of Indian Society of International Law, member of Indian Council for Arbitration, member of Bar Council Kerala, a visiting faculty at various universities in private international law, a frequent speaker at national and international forums in India and Europe. Because of the paucity of time, I have to restrain myself into highlighting only few achievements of Sir. I warmly welcome Sir to the International Conference on Private International Law. Sir, thanks for accepting our invitation, and we look forward for your valuable expertise, rich experience, and your opinion. I request you to join us and deliver your keynote address on this subject. Thank you, sir.
Good afternoon to all of you. Respected President of this university, who is sitting in Vellore, the Vice Chancellors, our respected President of ICPIL, Professor Dr. Manoj Kumar, Executive President Hegde sir, and all our executive members, senior members, and the respected Dean of this university, Professor Banerjee Chaka, and all the faculty members, respected faculty members, and colleagues, and dear students and participants. It is an honor for me to be here and to take part in this session. And as I always say, a lawyer is a learner. Every day he learns, and he has to get up at 5:30 and he has to sit till 11:30 at night, and he has to write, read, and argue the case before the court. And that is what I do, being a practitioner either in India or UK or in Europe. I am lucky to be a private international law expert, but Gerard sir has clearly said it is a boring subject, and I do completely agree with him. And therefore, I give him a suggestion or a joke that is generally talked in Europe. Most of the private international lawyers in Europe often go for divorce because they don't know exactly the jurisdiction of their disputes. In every family, in every couple, there will be dispute, and either husband or wife start disputing, and we immediately think, where does the dispute has its home, jurisdiction? And secondly, what is the applicable law? So that is a joke that generally being discussed in Europe. When one Indian died and went to heaven, God asked him at the gate, which room do you want? Then he said, there at the end near to the beach. Then he said, okay, you go ahead. Then there is another German man coming, and he also said the same. These both guys have gone there, old people. They don't have teeth, they don't have even eyes, but they have gone to the beach rooms. Early morning when they have got up, they both got up early in the morning and looked at the beach, but they could not see anything. They have seen only the old men and women. They have come back to the God and said, what is this? We don't expect these kind of rooms. We expected something beautiful at the beach. So there was a dispute. Again, God does not know which law is applicable. God was in doubt domestic law of India or domestic law of Germany or the international law of these both countries, which is the private international law for the private people. This may interest you, and this should be an inspiration for you to study. There will be always some case, starting from the beginning till the end, and even after the death, you will be having a private international law dispute. And I should say, when you talk about private international law, as Professor Banerjee rightly introduced, thankfully remembering Jairaj sir contribution as well as Professor Govindaraj's contribution, also Professor Jambolkar contribution. I also thankfully remember Professor Ulrich Huber, who lived in the year 17th century, who has coined this sort of conflict as conflict of law, whereas Professor Carl Friedrich von Savigny in the 18th century, followed by Professor Joseph Story in US, termed it as private international law because it is a law that solves the problem. It doesn't make any conflict in the conflict. So they have approached this issue from the positive side. When I was in Germany, we are talking about data protection. 30 years back, I was also sitting like you as a student in India, in UK, in Germany, and also in US. And when presenters made their presentation, I also went back to my college days. And when the Professor Brinda Mene, who is hailing from Maharashtra, presented that in the new world, data protection is sometimes like a big brother, as written by George Orwell in the book called 1984. I have written an article on that during the period of COVID, because we all are subject to and also addicted to online proceedings. We lawyers, there is no other option. So everywhere only online consultation, doctor consultation, lawyers consultation. I have also done my practice in Germany, Europe, everywhere online. So then I felt myself that where are we living? And what is the law that controls us? Then I remembered the book that I have read 20 years back, written by George Orwell. And I have made the caption for my article, "The Big Brother Watching All of Us." That is the term that I have coined for the data protection. Coming back to data protection. In the year 1999 or 2000, there is a very famous managing director called Professor Ron Sommer, who was the managing director and chairman of German Telekom. At that point of time, I was working as a lawyer in a German international law firm, wherein I was responsible for the IT department. Prior to that, I was responsible for automobile industry, and I have brought BMW to India during the period of 2002 to 2006, and I brought it to Chennai. So during the time of Ron Sommer in German Telekom as managing director, all of a sudden he has got an excellent name everywhere in the world. All of a sudden he has to resign for the simple reason that his employee has leaked 1,100,000 data of the customers. And he had to leave. And his salary, according to German terms, that was in mark, not euro. Euro was introduced in the year 2000, but it was in mark. He has lost his job. He was very sad. And afterwards, we have brought him to India to head the Indian Telecom. Another example, and I want to show that as well. There was a company, and it is a bank, German bank. That bank wanted to outsource its activities activities on software to Indian company. So they have searched for a partner and they found a partner in Hyderabad. But the server is sitting in Ireland. As you know very well, after the Brexit, every company, every European, American company, European company, African company and South American company has moved their servers to Ireland from UK. Earlier it was in the UK, but due to Brexit, they have moved to Ireland. So server is sitting in Ireland. The company which collects, fetches, that is in Germany. What do? They collect the data of Germans and Europeans for various banking transactions. And then they have entered into an agreement with a German company for processing their software, and that company has its mother concern in US, but they have outsourced their work to Hyderabad. I hope you understand the complexity of the issue. This is the situation wherein data protection plays a greater role. What is data protection? Data protection is actually to support the system wherein the data transfer is properly and legally transferred. No parties injured. And what has happened to this transaction? Finally, in US, there was a South Asian man sitting in US company. He doesn't have, in fact, control over the software. So Indian company does have a very small window to get into the software. Only the Indians can get into the software other than the German fiduciary. What is fiduciary? The one who collects. And the principal, according to Indian Data Protection Act, that is the citizens. Over there, that is the principals. They have given their data, complete data, banking data, complete secret. And this South Asian guy who is sitting in America, he was controlling the process of data transfer. And that shall not be taken back to US. And there is also another case subsequently to that effect in the Europe. So how do we save this situation when we have such kind of situation in India? I'm just giving you an example. I have written here two scenarios. Can you please connect it? Can you please connect this? So anyway, I have given you two scenarios. One is that because I don't have the connection. Let us take two companies. One is German company and another is Indian company. How do we proceed with that proposition when it comes to data protection? European data, so German company is the fiduciary, is the company that hands over the data to Indian company who has its location in Hyderabad, which is regulated by Data Protection Act. So let us call Data Protection Act. It is easy to say. Otherwise, DPDP Act is the Digital Personal Data Protection Act 2023, followed by Rules 2025, which is implemented on November 14th, 2025. In Europe, whereas it is not a law or act or statute, it is regulation. What does it mean? So even the private international law, unlike India, they do have clear-cut statute. And they have incorporated in the act as well. So they have made it as a regulation that is a European Union regulation. And all the countries have accepted it. Some countries have incorporated that law into their internal law. Otherwise, most of the countries implement it as very origin and genuine raw. So as per the GDPR, they don't accept Indian quality of the process of service and maintenance of the software by the Indian staff. They don't allow. Restricted. Transfer of data is allowed. Not complete. Whereas Indian DPDP Act allows completely. We have no problem. We have allowed it. Of course, there is restriction. There is penalty. If you do mistake, if we are not allowed to transfer some data to companies which has its origin in Pakistan or the country with our with the enemies, with our enemy countries, we are not allowed to do such kind of data transfer. Also, some African countries wherein you don't have strict data protection laws. So they don't allow all the data protection to come into India. So how do you manage that? This is one of the case that I manage at least 3 times in a year. So you have to write SSC. What is that? When you write international contract, and Gerard, I have heard his speech as well. When you write contract and all, international contract, you can write SSC, standard clauses. And in that standard clauses, you have to have a clear-cut milestones and supervisions, controls, as controlled by Germany. So what is their control? Their control is very strict. I have also law office. Even for the law office, I have appointed internal data protection officer. That data protection officer is being paid by me. And he is reporting against me if I do some mistake. And one of my subsidiary company in Europe is doing also the visa processing. That is a subsidiary company. It is not direct law company. Very strict internal data protection, and I also pay salary to the data protection, external data protection officer who is a lawyer. In India also right now we have a new Gen Z employment coming up in Data Protection Act, data protection officer. So there also they have external data protection officer. I have to pay. And what is their job? I have to, my staff, technical staff has to report every day at 4 o'clock or 3:59 to him. Send a message with the complete compliances. 4:45, the external data protection officer report the same with the German government's data protection board. This is the way, and especially when it comes to passport, when it comes to legal document, when it comes to OCI, when it comes to any other documents, it's very important. Otherwise, you are in trouble. There are, MEA experts are sitting here. There are outsourcing companies appointed by India government as well as many other foreign government for the processing of visa as well as passport and other consular services. All the foreign companies have strict data protection law, whereas the companies coming from India, they don't bother about all those things. And accordingly, very recently, there is a case going on against an Indian company, and luckily it was terminated by Indian government too. Because there is no data protection. Data should be protected. Germans, English people, Europeans, they give utmost value, and we also give. And that is why Supreme Court has clearly said in Puttapurthi that Aadhaar card and PAN card cannot be linked together. Then you get complete data. Even now, banks are demanding the same, which is illegal. Because you get complete data, and that is not the job of the government. If the government gets complete data, then what will happen? Big Brother, 1984, George Orwell. You have to remember all those things. So Data Protection Act is very much relevant in today's life. Otherwise, we all become the subject of private international law today or tomorrow. I think I have given you necessary problems to think about it. Now you understand where we are. So private international law gives you 4 problems and also 4 answers. What is the problem? Where is the data? How data is being transferred? When the data is being transferred to India, what is the law? So when we talk about German-India data transfer, I look at the German agreement at first and SSC and many other contracts. If you can connect, I will show you all the real example and which I am doing right now for a bank. I don't show the bank, but I can show you how this is happening in the real world. More than 100 pages I have given to them as a due diligence report. They said nothing. It is called TIA, Transfer Impact Assessment Report. Or, it depends, Indian Data Transfer Impact Report. For that matter, I have to assess at first their country's law, and I have to assess whether that agreement and transfer, real transfer of the data is subject to their law. Then I have to look at Indian law. Because you are finally Indian company which process the data. And that company is responsible for Indian government, Indian law. So you have to be answerable to that. And where do you file the case? Jurisdiction. So, applicable law, jurisdiction, all these issues come up in such kind of matters. And it is for the international, private international lawyers to settle these issues. And I try to give you, in my 15 to 20 minutes assignment, the most important aspect with respect to the problems of private international law. And I thank you for the opportunity. I once again congratulate the university and Professor Banerjee Chakka for your successful implementation of this program, and it is being carried out successfully. Congratulations, hats off. And private international law, as Sir has rightly said, it is bit boring. It is bit, dry. But at the same time, if you make it, you can make it successful. It takes little time. You have to be patient enough. I hope you will be having all that patience. Thank you very much. Have a nice day.
Thank you so much, sir, for your thought-provoking keynote speech and highlighting and flagging the issues like data protection, data privacy, and all the jurisdictions which are facing such problems across the globe. Moving forward, it's my privilege to introduce another keynote speaker, Professor Dr. Kondaiya Jonalagda, our distinguished academician and an accomplished scholar in the field of law, currently serving as a professor of law at Maharashtra National Law University, Aurangabad. Professor Kondaiya brings with him over 2 decades of rich teaching and research experience. Since joining MNLU Aurangabad in the year 2018, he has played a significant role in strengthening legal education and academic excellence. Prior to this, he has served as an associate professor at National Law University, Odisha, where he has also contributed as director of distance education and SWAYAM coordinator, promoting accessible legal learning. His academic journey includes a long association with National Law University, Bhopal, where he served as assistant professor for nearly a decade. He has also been actively involved with the University of Madras, contributing as a research fellow, project assistant, in the chair on intellectual property right, and as a resource person in distance education. Professor Kondaiya has also shared his expertise as a visiting faculty at premier institutions such as Gujarat National Law University, Dr. Ram Manohar Lohia National Law University, and KIT School of Law. His academic excellence has been recognized through prestigious awards, including L.C. Miller Gold Medal, Dr. A.L. Mudaliar Prize, and Justice M.N. Rao Prize. Beyond academia, he has contributed to policy and regulatory discussion as a member of the National Indian Competition Expert Cartel Working Group under the Competition Commission of India. He has also served as the Vice Chancellor in charge of MNLU Aurangabad. His areas of expertise include private international law, corporate law, securities law, international law, and competition law, making him a well-rounded authority in both national and international domain. We are truly honored, sir, to have such a distinguished academician among us today. Sir, thanks for accepting our invitation and joining us today. I warmly welcome you to the 5th session and request you to kindly deliver your keynote address. Thank you so much.
Good afternoon to all, and at the outset let me thank the organizers, the Vice Chancellor of VIT and the Dean, School of Law, Dr. Banerjee Chekka, and all the senior students of Madras University or the scholars of private international law, just who are sitting before me, as well as to the people who asked me to study the private international law from Madras University. As when you have seen before closing of the earlier session, Professor Lakshmi Jambolkar and the Professor C. Gerard sir, when I was a student of law, they said you start your research in the subject. And that time actually, okay, I thought how I will do the research. Somehow now after 25 years, I am sharing some of my thoughts before the same teachers who taught me the subject. So if any mistakes are there, I think my teachers will carry on. And I will be taking the subject in a way where the private international law really happens. As far as employment purposes are concerned, as well as to the placement for all of you, because I've been the part of the law schools more than 2 decades. Every young student wants, if I spend for 20 minutes here, what I will get. So let us have something on private international law, as already advocate said about the data protection laws. There's a deal somewhere. No? The data in transfer. It's gone. No, it is there. Yes, data is protected, sir, actually. So we are also entering the data. So I think yes, now it's working from there. Before coming here, I had a trial test. Yes, now it's working here. So as a teachers, we all, learning the data and other important process in technology also to make some of you people are very interesting. Then I also use the tools that one. In this slide, you will find where this subject originates daily life. I have given the 3 examples. One is a share agreements, share purchase agreements, as well as we have one more is on the power purchase agreements. These are daily basis we see on the purchasing of the shares. We have one of the landmark case law which is pending today on share purchase agreement led the arbitration is the Vodafone case. Vodafone case where various arbitrations are going on. People look from the tax law issue, but even we have arbitration law issues. Then we have another aspect talking about the data in the sense of, choice of law and the party autonomy. I don't want to touch upon that. The other important point is that you are selecting your own agreement in the traditional form. But in 2026, we don't have an option except the smart agreements in the most of the cases. Here there is a slide which I put it the one of the case, commercial contracts read with the, what we can say, the forum shoppings. I have written one of the case, Ritu Kumar versus Jamia Private Limited. It is a case on cryptocurrency. She purchased the crypto of 1 lakh rupees and she got the profit of 7 lakh rupees. Suddenly, there was a crash of cyber website in the Singapore. According to the agreement, she has to file an arbitration in the Singapore. But she said, I purchased in Madras, office is in Madras. Then she approached the Madras court under Specific Relief Act. Madras High Court said very clearly, since you have a branch here, and the clauses which are there in the smart agreement is not applicable to India, therefore you pay her with interest. Even though she lost her asset in the crash in the cyber world in Singapore based. This judgment gave a new openings in the system called crypto as an asset. Smart contract clauses are not automatically applicable to the consumers. So this is going to make some of you, if anyone is having a crypto and you can take up this case, you can tell them it came only 3-4 months back, which is the crypto as an asset and the digital assets cases. Then this is very important slide which I am going to talk. Majority of the disputes in the world on arbitration law on 4 to 5 aspects. One is on the mines, minerals, coal, and there are 2 minings. One mining, we all know coal mines. Recently, when I started learning myself, there is a subject called data mining. Data mining requires a lot of water, a lot of resources. So be careful in future if somebody says mining, is it data mining or coal mining or the mine mining. Be clear on that where the system is changing for the future purposes. The 2 legal instruments which creates an arbitration is the license and lease. These are the agreements under the VITs or any commercial agreement. Rarely we go for a sale deed. As a law student, you draft an agreement called lease and license. Therefore, it will make you the subject of private international law on the day one. Then this is very important one which you want to put. Only 1 minute I will take it here. As a lawyers, what we require from an award. We have section 9, section 34 of Arbitration Conciliation Act. Once you have an award, there are 5 methods of enforcement. One is delivery of property, attachment, arrest, appointment of receiver, as well as the court order reliefs. These are expressly given under the foreign arbitration as long as everything is properly done, if there is no dispute at all. Therefore, you are given here second part, how the determination is being done and approaching of the municipal forums. Then the foreign award is also treated as if it's a foreign judgments of section 13 of the CPC. So therefore you don't find so much of disputes. There are 6 grounds which talks about the when an order or award is a valid one. This is now becoming the part and parcel of every one of us. Section 13 of CPC and 44 of the A of the CPC. Then this is where I want to tell young generations in technology, cut and paste of arbitration awards. Section 13 has given something which where award can be vitiated. Recently I came across some of the great arbitrator, the former judges of Supreme Court of India drafted an arbitration award. Singapore court said this arbitration award drafted of cut and paste, plagiarism or plagiarism. Don't follow cut and paste of arbitration law. If judgment is copied, arbitration agreements are not enforceable. How the new people are using about the drafting. So be very careful. This may be one of the ground. You can use a technology. Now we are also having the legal, what we can say, the tools. Like I am also using one of the tool, the paid version of the Notebook LM. I check more than twice whether the data is right or wrong. I also manually cross check. If I use completely the prepared by the tool, then somewhere I also end up in the wrong methods. And we have the domestic and foreign awards and the set aside and refusals. Yes, now we have the reciprocal under the UK, UAE and Singapore. And this is the one I want to take 2 minutes on this judgment. This has opened a Pandora box of arbitration awards. Gayatri Balaswamy case. Whether an award given by a foreign arbitrator can be modified or set aside. So now the Supreme Court said, you cannot, however you can. Then they gave some impact, 4:1, when you can modify a foreign arbitral awards. The 6 grounds they have given. Due to paucity of time, I'm only skipping, right? I will forward this, ask the organizer to share the PPT later. Now the Supreme Court of India has said you can modify. Now the question will come, if you go for a modification and set aside, the complete process of arbitral award given outside India come back to the first step. So therefore, and this particular case also has given how to drop the contract. One point I appreciate the jurisprudence and learned from the Supreme Court of India, as one of my panelists was telling, the people who draft the contracts are using very complicated clauses where it becomes very difficult to see the business wisdom of the drafters. When the people uses the complex clauses with a fraudulent manner, then court has to interfere very object of a contract. That's where they comes with regard to the modifications. This is what you can say permitted one, clerical and typographical errors, computational mistakes, interest calculations, and serving invalid. So now we have the modification of the awards are permitted. Yes, we have the international covenants, New York conventions, as well as to the Geneva Convention under the Arbitration Act. And that has been also discussed in some of the conferences. This is a very broad view how the foreign awards are comes into the Indian law. Here I want to tell the 4 concepts of Indian domestic law talks about international law. First concept, which is not clear, habitual residence. Second concept, ancestral model law, Geneva Convention, and the New York Conventions. These are expressly used under the Domestic Act, where our domestic law is referring to look into the outside the country. So therefore, every student has to see that treaty law as well as to the customary law or the law of merchants, how they are providing the different mechanisms to address the issues of the international commercial laws. This case, most of us may be knowing, we have 3 judgments now. One from Supreme Court of Netherlands. 1 week back, we have a judgments from the Australian High Court. These are 2026, and also from the international boards. Here is a very simple facts of the case. I may take 2 minutes. Devas is a company which came to India for telecom space agreements, and there was an investment to India. In the history of India, in 2021, during Corona time, a company was dissolved within 24 hours under the Companies Act, Section 271. They said, Government of India, it is a fraud company, then we disclose. Whereas, every part of the world, Devas is getting a favorable orders in their side, except in Australia. So now the Devas is stating that whatever investment which we have made, it comes as indirect expropriations. Now the 3 subjects are coming: public international law, enforcement of arbitral awards, then comes about how to draft an agreement. Government of India said, because of telecom policy, we want to cancel the contracts. So I request every student to follow this case. It gives lot of arbitration cases where lawyers mint the money like anything, because it's a bread for the lawyers and also meal for the teachers and students. In a law firms, you draft the big contracts and also appearing before the various courts. So Deva's case has said that one important point of international law, signing of any convention doesn't mean waiving of the sovereignty. So every state has a sovereign power. That is what is laid down even by the Australian courts. This is what I want to put it. And now you can see where we are in India. People are getting from the Netherlands, now coming back to the Australia. This is where the private international becomes a combination of various parts. So this also talks about how private international is connected from India to the Europe, Europe to Australia, where lawyers are looking for the international investment law, international commercial laws. Yes, sorry. This I already told the Vodafone case, which we have international arbitrations. And there is a new subject which has been developed, international administrative law, out of these lawmaking or treaties. The recent case which I want to put all of you, maybe we all do the shopping, and there is a concept called treaty shopping, and it is a case related to everyday life, Flipkart and Walmart. We all think Flipkart is the owner, but today Flipkart is not the owner of the Flipkart. Flipkart is already acquired by the Walmart. We have a case called the Tiger Global case and the JR. It's with there. Yes, it's the case of the AR versus Tiger Global, when the Tiger Global is nothing but the Flipkart companies and also Walmart. Walmart of the Luxembourg acquires the company of the Flipkart in the, I think somewhere it's not working. Yes. Here one of the point which I want to tell, kindly see this photograph and learn the, if you want to provide a remedy in law, okay. If you want to avoid the benefit in law, here they applied the principles of private international law, residence of individuals. If you create a company and company has a residence for a fraudulent purpose, you cannot take the advantage of the India versus Mauritius treaty. A Mauritius company which was there, the Flipkart, created for tax avoidance and fraudulent purposes. The director of the Walmart, who is there in the Coleman, P. Coleman, based in the US, then the Indian court said the company is controlled and held by the Walmart Coleman. The test of the individual, residence of the individual is applicable to the company where they control. Not the Mauritius where you have the physical only for the sake of legal. So this also created that how the corporations try to have a different residences. This is a very fundamental subject which is studied in private international law: domicile, residence, habitual residence, tax law, and all other subjects. Oh, there is some problem. No, it's not working. Some problem. This is one. Yes, this we have already seen. Look through, look out, lot of people have written, because I remembered one of my super senior former Vice Chancellor of NLS, Professor A. Jaygovind sir, has written a lot on look through and look at transaction of the section 8 and 45 of the Arbitration Act. Some of you can see his articles later. Then coming to the last slides, I think there is some problem. Yes, now let me. Yeah, these are some of the cases which I thought I will tell every one of you. The last line of here, the two subjects which are newly added, international insolvency law. Recently in the parliament session, we have included a negotiation between the cross-border attachment of properties, cross-border insolvencies. Here there is a new concept has come, almost it was discussed now and then, the concept of group doctrines and single economic entities. Group doctrine has taken the new dimensions. The old concept of holding and subsidiary company is not there. Now if they are a part of the group, even though if you are not signatory to an arbitration agreement, doing a single economic entity, automatically arbitration agreement follows to the non-writing parties also. I will repeat again. You don't require express writing of an arbitration agreement to have an arbitration if the company becomes as a group companies and having the single economic entities. So therefore, there is no case where a company can avoid. People may say, then what is an object of party autonomy? The counter argument is that corporates are devising a corporative manipulative devices to avoid that, and they have to bring a justice to a common justice to every investor. They devise the principle called about the integrity in the markets. It should not be called as a corporate frauds. Now coming to the last slide, this is where I stop my presentation. What can we way forward from here? As a new generation students of Gen Zs, or what we can say for futures, and see the natural resources of India or anywhere, which becomes the source of investment agreements, arbitration laws, for somebody bread and butter, for somebody it is a business, and there should be a balance between the business and the other one. One of the point, last bottom of line, is that every investment should be for economic development. If there is an investment which is not for economic development, automatically it comes as an exploitation. So the bottom line comes, you can have an investment, then arbitration for the economic development of the state, automatically every state will progress. With this, I will stop my sharing of my thoughts. It's not my opinion. I'm sharing some of my thoughts, what I learned recently in commercial law. And I thank the organizers for giving this opportunity, and all the students for patiently listening. Once again, thank you one and all. Thank you.
Thank you, sir, for sharing your knowledge on arbitration, especially on highlighting the cautions a lawyer must take while drafting arbitration clause, and also flagging the challenges which courts are having while implementation of arbitration awards. Moving forward, I request Monica to start the presentations.
And the first participant of this session is Ms. Monisha Devi and Madhuri from VSL, VIT-AP University, on the topic No Forum, No Law, Jurisdiction Conflicts in Cross-Border Smart Contracts and Their Implications for the International Trade Law.
A warm greetings to one and all present here, respected chief guests, dignitaries, faculties, and my dear friends. A very good afternoon to one and all. Let me begin with not with a legal proposition, but with a question that how many of us made an online payment today morning or received a automated, generated invoice or booked a cab, or in these many days entered into a cross-border or transaction? If the answer is yes, and I suspect it is, then we have already participated in the architecture that my paper examines. It's just that simply it's unnoticed. And that is precisely the problem. So our paper is titled Cross-Border Smart Contracts, Their Impact on Trade Law. If we see the foundational architecture of international trade law was built on a simple premises that contracts will have parties and transactions will have locations and disputes have forums. Smart contracts on blockchain destroy all three assumptions simultaneously. First, identity. When an AI system autonomously generates a contract and executes it via a cryptographic key, whose consent are we recognizing? The developer who built the algorithm, the enterprise that deployed it, or a machine that has no legal personality? Second comes the location. A blockchain transaction may be validated simultaneously across nodes in Singapore and Frankfurt, but there is no lex loci contractus, that is no law of the place of contracting. The issue is not arising from the legal ambiguity in drafting. Rather, it arises because of the transactional architecture, a blockchain executed smart contract that structurally is incompatible with the territorial sovereignty assumptions upon which the private international law is completely built upon. When the smart contract is a self-executing digital agreement, and when the pre-agreed conditions are met, the contract executes itself automatically
instantly, irreversibly. Now considering the scale, the smart contracts today govern international trade finance, insurance claim automation, cross-border supply chains, decentralized lending worth hundreds of millions of dollars, and increasingly the AI-generated agreements. But to be noted, the World Trade Organization estimates that blockchain-based trade instruments could reduce global trade costs up to 15%. And the decentralized finance processes transactions worth trillions annually. And yet, no one binding international legal instrument specifically governs them. Therefore, most people interact with the outcomes of smart contracts every day through digital payments, insurance triggers, e-commerce logistics, without ever knowing a contract was formed, performed, and closed. That invisibility is precisely the problem. What renders this legally significant, legally dangerous, is the intersection of three simultaneous disruptions. First, jurisdictional indeterminacy. Blockchain nodes executes multiple sovereign territories simultaneously, rendering traditional connecting factors under private international law, like habitual residence, place of contracting, lex loci solutions, effectively inoperable. Second is the formation and its uncertainty. When an AI system autonomously generates a contract terms, the foundational doctrines like consensus addendum and capacity and the duty to be read are not merely strained, but they go structurally undermined. And third, the most critically for 2026 is the liability, AI liability attribution. When an autonomously generated AI contract causes harm, existing tort frameworks provide no coherent mechanism to allocate responsibility among developers, deployers, and the decentralized platforms. Therefore, in the view of the scholar Chesterman, as rightly identified this as the regulatory frontier, as the doctrinal vacuum. In a sum, these are the research questions and the problems being addressed in our paper. The further part of the paper will be taken by my friend Madhuri.
Good afternoon to all the dignitaries on the dais, faculty members, PhD scholars, and all the students. The further part of the paper will be discussed regarding the comparative analysis and the recommendations. So when we start with the comparative analysis, this paper conducted a comparative analysis considering the 5 jurisdictions, civil law, common law, and hybrid legal system. First, when we talk about the comparative analysis and the contract formation, so in the contract formation, the different laws and confusing results. So across the countries, there is no uniform law how the smart contracts or how the smart contracts are legally recognized. When we take the example of Arizona, the Arizona accepts the smart contract signature, while the UAE degree law number 46 of 21 clearly allows electronic and blockchain based contracts. However, an Indian Information Technology Act 2000 does not even mention AI generated contracts. At the same time, Iraq bans cryptocurrency but still allows electronic contracts under its laws. So this creates a confusion between the businesses and individuals, which law applies. So which law applies, especially in the cross-border transactions. When we talk about the jurisdiction, traditionally jurisdiction is based on the where the party lives or where the contract was formed or what parties agreed. But when it comes to the blockchain, blockchain is decentralized. So when it is decentralized, we don't know about the location. So when we don't know about the location, we cannot consider which rules applies. So even if the smart contracts includes the clause of choice of law, there is a AI cannot make the valid legal decision as the humans make. So right now the law has no clear answer to this. So when we talk about the liability, who is responsible? When the smart contracts are created by the AI, when the wrong was committed by the AI,
the law struggles to identify the responsibility. So should liability fall on the developer who created the AI, the person who deployed it, or the platform hosting it? So this paper applies the legal principle of contra preferentiam, which means that unclear terms are interpreted against the party who drafted them. Here the argument is simple. If an AI system creates ambiguity, responsibility should fall on the person who deployed that system. So this is not a new rule. It is just applying on existing principles to the new situation. So when it comes to the consumer protection, there is conflict arises between two laws. One is GDPR and one is blockchain. Under the General Data Protection Regulation, it is designed to protect the individuals. The individual has a choice. They can ask the company to delete their personal data. But when it comes to the data in the blockchain, it cannot be deleted. It is stored. So businesses using the blockchain-based smart contracts face a serious dilemma. If they follow GDPR and try to delete user data, they technically cannot do so on the blockchain. But if they keep data, a blockchain required, they may violate the GDPR rules. So the businesses are in the dilemma. Like which rule they should follow, and if they follow the one rule and they are violating the other rule, so they are facing the penalties. So when I go to the recommendations, there should be the binding international law. The first solution is to create the global binding law framework for smart contracts. Existing models like the UNCITRAL model, law on electronic commerce are helpful but not legally binding and outdated for AI and blockchain. This paper suggests that organizations like UNCITRAL should create a binding international convention. It should clearly regulate contract formation, legal capacity, liability, and enforcement, similar to how the New York Convention on Arbitration 1958 successfully standardized the arbitration law worldwide. And the second recommendation was to create a specialized system for the blockchain-related dispute, like resolving smart contract disputes globally. Current systems like the European Union online dispute resolution platforms and UNCITRAL's technical notes are limited and not enforceable across countries. The paper suggests building a blockchain-specific dispute resolution system linked to the New York Convention so that decision can be enforced internationally. Proposed ideas like the blockchain arbitration forum already show that the technology exists, but the missing is the legal recognition. Thank you.
Thank you, Monisha. And the next participant is Miss P. Sanjana from KL University. She is presenting on international arbitration and online dispute resolution. Warm greetings to all present and good afternoon, one and all. My topic for today is arbitration and international dispute resolution. We live in an era where digital commerce is borderless, yet our legal systems remain stubbornly territorial. Traditional courts are paralyzed by the jurisdictional uncertainty. When parties and assets are spread across the globe, no single court wants to take the lead and actually deal with the case. Today, I will evaluate the two primary alternatives, that is international arbitration and online dispute resolution, and propose how we can actually fix their current drawbacks. Let me begin with a case study, that is Rudiger Winkler versus Google LLM. The consumer is a German consumer, and the headquarters is in Ireland, and the parent company is a US parent company. All the courts applied the doctrine of forum non-convenience, and the court case got dragged on for years. And it actually, after a few years, it ended in a legally fragile ODR resolution that is only binding within the platform's term of service and was not an enforceable judgment, as ODR does not have a legal enforceability. Next. Okay. Let me continue with arbitration. International arbitration is a strong tool because of the New York Convention. It obligates 172 countries to enforce awards across the signatories. It offers neutrality and protects trade secrets through confidentiality. Let us look at arbitration to Indian context. India has modernized its framework via 1996 Act. However, Indian courts have not clearly recognized cryptocurrency as a legal property, making it nearly impossible to enforce awards involving digital assets. Let me move on to online dispute resolution. Online dispute resolution was popularized by platforms like eBay and Amazon. It is both unmatched in speed and scale, but it has a hollow promise because it is not legally binding. Unlike arbitration, ODR has no international treaty for enforcement. Large platforms like Amazon act both as rulemaker and judge, where both the rules are made by the platform and even the judgments are given by the respective private platform, which leads to bias in the judgments given. And these are frequently rejected by courts due to lack of human deliberation and the chance of bias. Let me move on to blockchain and smart contracts. As we move into the metaverse, we face structural enforcement challenges. Claims brought against anonymous people address rather than identifiable people have brought challenges. No court orders can compel a party to surrender a private cryptographic key. Smart contracts are self-executing, which creates a paradox because usually it is great since they're self-executing, but they are irreversible. So the harm is usually done even before a lawyer is actually involved. I would like to suggest 3 pillars of reform through my paper. To make these changes, I would like to make these changes to fit the digital era. A binding ODR convention modeled on New York Convention to make it globally enforceable, a global certification body which oversees the decisions given by the private parties, and to meet the minimum standards of due process and human oversight. I would like to conclude by saying that the digital economy will not pause for law to catch up. If we need a system that is both efficient and just, we must bridge the gap between technological spread and legal accountability. Thank you.
Thank you, Sanjana. And the next participant is Dr. V. Sujata from VIT Chennai, who will be presenting in online with a paper titled Rethinking Private International Law in the Age of Artificial Intelligence. Ma'am, you're not audible. Ma'am, can you please unmute?
Yeah.
Yes, ma'am, you're audible. Please continue with your presentation.
Good morning, everyone. I'm Dr. Sujata V, VIT Vellore. This paper is co-authored with M. Redakis, final year LLB. Our topic is rethinking private international law in the age of artificial intelligence. We will look at how AI challenges jurisdiction and the type of law and discuss the possible ways forward. The next one. In the legal context, there will be human actor, legislative action will be done, and direct harm. So the place of law is visible to all. The result is we can fix the jurisdiction in the legal context, in practical legal context. But in all context, the jurisdiction will be in place. That is, the data will be trained in the jurisdiction, that is in state, and in another state, the cloud server will be there, and victims will be in field. The data will be harvested globally. So it is very difficult to find the jurisdiction where the harm has taken place. There are three critical structures in the legal architecture. The first one is who is the person, who is the legal actor. If an autonomous person makes a decision resulting in the harm, means who will be responsible for that. The second structure is where. If developers, servers, and victims are in different countries, whose courts and have the authority to work with states. The third one is the liability. How the victim through a casual link when the technology decision-making process is an neural network. Locus acting with locus domain argument. This island, so just I'm going to explain this with a case law. Suppose if an US company develop a supply chain algorithm in our land, it causes a significant losses in Tokyo means, then the question arises, which country should the Tokyo company approach for the legal force? Either America, Ireland, or Japan. This situation underscores the crucial issue in private international law regarding the responsibility for AI. How the law was created and how the algorithm was wrongly used in American company. The answer to this is nothing but a black box problem. What is black box problem and what is AI today? AI is no longer just algorithms make autonomous decisions. It impacts corporate, financial, and legal sectors. The question is, who is responsible when AI causes harm? What this happens? Why there is a legal problem? Decisions without human. Global impact, because it takes global impact, because it is trained by various sets of data, not from a particular country. No clear liability. Laws are local, but AI is global. This mismatches in regulation and enforcement. Why this happens means AI handles a huge amount of data across borders instantly. AI systems can make decisions independently without direct human control. AI operates across multiple domains and jurisdictions simultaneously. This creates a complexity. What is black box mean? Because even the creator of the algorithm doesn't know how it goes. We are humans, just we will not be blindly accepting the machine telling us. If you are inputting the data to it will give the correct result. But that is a continuous product will be done. Why that means AI makes the system faster and more effectively. There are even downsides also. Where there are even downsides are made programming bias, digital patternism, and then science tipping is going informed. Erosion of trust AI. So what we have to do is, we need to move away from this black box system. But more is, companies hold on due to this consumer paradigm. Companies like Amazon, Netflix aim for hyper-personalization, which necessitates processing large volumes of data. That is why black box systems are advantageous for achieving speed and profitability. Therefore, effective black box governance is essential. It should be enabling public audit of decision-making process within these systems. The problem is for AI is no transparency, no accountability. As I told you, but with an example, the Silicon Valley example, so US is making a supply chain algorithm, and it is making the algorithm in Ireland, but logistics, the victim is nothing but Tokyo, that is Japanese company. So the company, where it can go and it can sue a And what is this scenario highlights the limitation of traditional private international law. So action is taken place in USA, damages in Japan, which 20 laws apply. In Japan, the cases should be investigated under the common law because they don't have any specific legislation for years. This raises the question of whether Japanese companies should adapt to American law. This is refers to the trap. Affected the logistic company ran the European Union instead of Japan. How does revocable presumption law in Europe work? In Europe, if AI passes a law, the law assumes that AI is the creator. The AI never is at fault. So this shifts the burden of proof to the company, requiring them to prove that innocence. This significantly changes the situation compared to the half-track. The European Union primarily lost international issues and this is nothing but conflict. So in our main system and all, we will be seeing that the term will be that, accepting the term. So nobody will see the check box, they will directly tick that and they will accept and they will go for. So that is nothing but contract. The row 1 for contract and row 2 for non-contractual matters like AI-related accidents, AI bias cases, such as gender discrimination in hiring, depending upon the victim's habitual residence, competing compliance procedures. We create smarter AI to meet European Union standards, promoting global data privacy. While this may appear as a legal imperialism, it is market-driven and could encourage broader regulatory adoption globally, supported by the organizations like workplace organizations and universities. What is the concept of loss? In 1973, the Hague Convention pertains on European Union countries and addressed the product marketing and harm. This makes that after that, the domain changes will be that. Suppose if we are going for the Google means Google.com, Google.org, like that we have this. So what in 1973 Hague Convention says that once the domain goes for, that is European Convention, .France, .Netherlands, if they are under the country of, if they are accepting the European Union territory law, the European Union law, so they have to make the domain which they belong to. So if it is so means, and then the currency they are using as a European, for trading, they are using the European currencies means, then they come under the European Union, the European law, and the European law says that.
Ma'am, can you please?
Nothing but the product liability. So whatever it is, it depends upon the product liability. What's the problem for AI is AI a software or even a product? The traditional law was designed for the physical goods, not for the intangible items.
Ma'am, can you please conclude your presentation?
Yeah, ma'am. It's like to answer the liability to product, not the developer. So, AI can find the solution within the just seconds. And what we are concluding is, in India, they are developing the AI based on the 7 sutras. One is clear location should be the eliminating the black box, discarding the systematic show, and the human-centric design oversight will be the progress should be the partner should be the. And these are the things checklists. Whenever the company has these things, the checklist should be carefully. They have to be checklist carefully, and then they have to do their own AI systems. So, large companies may argue that building the legal status to AI is crucial for limiting liability, raising concerns about the accountability and blame shifting, while trustworthy AI control valuable insight, its success depends upon sharing to the public. So what is the initial means hybrid liability model should be done? What that hybrid liability should be done means two things have to be incorporated. What are the two things means? One is that they have to go for the data sets that to be, and another one is nothing but they have to take the jurisdiction. This is the thing. So while framing the design of framework, they have to be go for this layer to wash out that the danger of ethics. One is nothing but the governance layer, another one is process layer, and another one is data layer. In governance layer, self-regulation should be done. In process layer, it should be monitored clearly. In data layer, training data sets should be done, and it is to be prevent inherited systems and bias. So this is the recommendation system just we are given in our paper. And this is the key takeaway. So artificial intelligence cannot be contained by the territorial static legal borders of the 20th century through the export of the European Union rules based on the standards and the adopting coordination of global organizations. International law is actually evolving to successfully govern the future of the global trade. Our legal architecture must become fluid, interconnected, and intelligent as the system it regulates. This is the concise version, the summary.
Ma'am, please conclude your session. The time.
That is checkbox list we have given, and then we have given the framework, and then it is to be responsible for the society. Whatever the company is responsible to the society. So these are the recommendation system we are giving to the analysis in this paper. Thank you very much.
Thank you so much, ma'am. And the last participant for this session is DVV Taniraj and Sanjana Kumari will be presenting online with a paper title Jurisdiction Without Geography, Private International Law at the Cross Borders of AI Native Transaction and Autonomous Digital Actors.
within a single jurisdiction. This creates an uncertainty, not because rules are absent, but because the assumptions of underlying them are changing. The central question of my paper asks is whether jurisdiction can continue to remain geographic based when transactions themselves are no longer territorial located. So in other words, if decision making becomes autonomous and distributed, so should jurisdictions still depend primarily on physical connecting factors? This is what my central question lies on. Further, I argue that this issue is no longer theoretical. So AI systems today are capable of negotiating contractual terms, executing obligations, and modifying outcomes dynamically based on real-time data inputs. So courts are therefore increasingly encountering disputes whether neither formation nor performance nor intentions can be easily located within a single territorial jurisdiction. So by this, I have made this classical jurisdiction framework, which primarily states that the classical private international law relies on connecting factors, such as the place of contracting, the place of injury, domicile of the parties, and party autonomy through governing law clauses. These connecting factors historically ensured predictability because they assume that legally relevant conduct could be located somewhere identifiable in space. So AI native transactions challenge precisely this assumption. Even when even when jurisdiction doctrine evolved through cases like one second maybe.
Sir, please conclude your session.
Right. So classical private law relies on connecting factors such as the place of contracting, the place of injury, I've already said. So basically, AI narrative transactions differ from earlier internet-based activity because artificial intelligence now is not merely a communication medium. Instead, it becomes a decision-making participant within a transactional process. These systems operate across distributed cloud infrastructures, adapt continuously, and blur the distinction between the formation and the performance. As a result, territorial anchoring becomes increasingly artificial. So this creates pressure on all transitional connecting factors. The place of contracting becomes difficult to be identifiable. The place of performance becomes distributed because across infrastructures, and domiciles becomes less meaningful when systems operate globally. Even server location proxies become unreliable in cloud environment. Together, this weakens the jurisdiction predictability. So I have made the comparative jurisdictional responses. So here, across jurisdictions, courts are adapting but not transforming their reasons. So the European Union uses center of interest approaches, and the United States applies minimum contracts and effects based reasoning, and Indian courts, particularly in banyan tree, requires intentional targeting of the forum. So these approaches improve jurisdictional reasoning but still remain rooted in the territorial assumptions. So these are the contributions. So my paper therefore proposes a functional jurisdiction framework based on 3 pillars. So one is the control, second is the economic impact, and third is the regulatory accountability. So first, the control-based jurisdiction focus on entities that design, deploy, or
Please
operate.
conclude your presentation.
Right. So the third, regulatory accountability jurisdictions links legal authority to jurisdiction that enable or benefits from the transactional activity. Together, these pillars shift jurisdiction from territory proxies toward the operational realities. So the implication of this framework extends beyond doctrinal adjustment because private international law must increasingly align with AI governance frameworks, data regulation regimes, and cross-border enforcement cooperations. So without such alignment, jurisdictions risks becoming disconnected from technological reality. So by this, I will be concluding my paper. So AI native transactions demonstrate that jurisdiction is no longer naturally geographic. and it's a functional approach that restores coherence without abandoning the functional value of the private international law. So jurisdiction therefore must increasingly follow function rather than geography. Thank you.
Thank you so much, sir. Now I request Swarupa ma'am to come on the dais.
Before going for felicitation, let me introduce another speaker, another dignitary, Mrs. A. Swarupa Reddy. She joined us recently, so I welcome you on the stage, ma'am. I take this opportunity to introduce her. Miss A. Swarupa Reddy is a practicing advocate before Supreme Court of India and the High Court of Andhra Pradesh. She is specialized in the field of private international law, apart from civil, criminal, property and constitutional law matters. She has done Masters of Law in International Law from Osmania University in the year 1996. She submitted a dissertation on execution of foreign arbitral award in India for the partial fulfillment of master's degree. She served as a research assistant for India in Indus Waters Kishanganga arbitration between Pakistan versus India before Permanent Court of Arbitration in the year 2012 at Peace Palace, Hague, Netherlands. Ma'am is also Executive Council member of Andhra Pradesh High Court Bar Association, Amravati, from the year 2024 to 2025. We are very happy, ma'am, to have you here with us on this occasion, and we welcome you for this session. And now moving forward, we are going for felicitation. I request our Dean, Professor Dr. Banerjee Chaka sir, to felicitate our keynote speakers.
Thank you for your time and consideration. Now I request Shama ma'am to propose the vote of thanks.
distinguished keynote speakers, esteemed delegates from across India, and my dear colleagues and students, it's a profound honor to propose this vote of thanks at the conclusion of the 5th session of International Conference on Private International Law. First and foremost, I express my deepest gratitude to our keynote speakers, Advocate Saju Jacob sir and Professor Dr. Kondeya sir. Your insights have provided us with a rich trajectory of knowledge. You have not only addressed the current legal landscape, but also have charted the course for future scholarship in private international law. A special word of thanks to Professor Dr. Banerjee Chakka sir for providing the platform and the resources to bring this international community together. I must acknowledge the tireless efforts of organizing committee. Also, to our delegates and paper presenters, thank you for your contribution. As we know that the vibrancy of a conference lies in its debates. Your rigorous research and the diversity of jurisdictions represented here today have truly made this session a global exchange of ideas. Lastly, I extend thanks to all the faculties of BSL, students, and all students who are volunteers for your invisible yet undeniable labor. Thank you all of you to be the part of this session. Concluding this, for the last time, thank you all of you. Monica, you may take the stage.
So the technical session 5 is concluded. The next session is at 2 p.m. I request the students be kindly here by 2 p.m. sharp. Thank you.
I now take the privilege to introduce you all our session moderator, Professor Kirtika Sahu, Assistant Professor at VIT-AP School of Law, completing her graduation and masters from Dr. Ramanohar University, Lucknow. Ma'am is currently undergoing her doctoral research in CSJM University, Kanpur. I now request Ma'am to please take the session forward.
Thank you, Lasya. A very good afternoon to all the dignitaries, colleagues, presenters, and my dear students. It is my privilege to welcome you all to Technical Session 6 of this International Conference of Private International Law in the Era of New Emerging Technologies, Issues, Challenges, and the Way Forward. As we gather on the second day of this conference, we find ourselves at a particularly important intersection where law meets rapidly evolving technology. The session will aim to explore these evolving challenges and reflect on how existing legal frameworks can adapt to technological disruptions while maintaining certainty, fairness, and justice in cross-border transactions. And I'm confident that today's session will provide us valuable insights, foster meaningful dialogue, and contribute to a deeper understanding of how law can effectively respond to technological transformation. Now, it is my honor to invite and introduce our first keynote speaker for the session, Dr. Sai Ramani Garimella, who will be joining us online. Dr. Gary Malla is an associate professor at the Faculty of Legal Studies, South Asian University, New Delhi, and a highly respected expert in the fields of private international law, international arbitration, and international economic law. She brings with her a rich academic and research background, having previously served as assistant professor research at National Law School of India University, Bangalore. She has also held various academic positions at reputed institutions such as University of Johannesburg, the Indian Institute of Public Administration, and ICPIL. She holds a PhD from Osmania University and an LLM from Andhra University and has consistently contributed to advancing research and dialogue in international legal studies. Dr. Gary Malla, over to you.
Yeah. Thank you very much. Good morning. It's actually morning here at Max Planck in Hamburg, and I'm here on a research work. So that's why I could not be there for the kind invitation from Professor Banerjee. Thank you very much for this invitation and also this opportunity to speak to this young and also very highly informed audience that I see here. Now, one of the key challenges that I was asked to address about this is emerging technologies is the issue related to how we would handle data, right? Now, a few years ago, just around the time of the second lockdowns around the pandemic, there was a case that was handled by the Kerala High Court related to how the data related to COVID patients shall be administered and handled. Now, what happened was that the Kerala government actually had a contract with a company which had an Indian entity. It's called the Sprinkler LLC. They had an Indian entity, of course, located with offices in Bangalore, but it's an American company, right? And that was entrusted with handling all the data. Right. Now, the problem was that this particular contract between the government of Kerala and the Sprinkler LLC had a dispute resolution clause where the dispute resolution was supposed to be happening in New York. Right. So the seat of the forum is basically the New York courts. Nevertheless, the issue was brought by a set of petitioners before the Kerala High Court saying that confidential data was being handled by and very likely to be taken out of the country. Right? Now, this particular issue actually brings us into a perspective about the kind of problem that we are facing. Right? We are talking about information about our population. Right? One, this is a geographically sensitive information. Secondly, this is a patient confidential data. And three, it is being handled outside the country. Right? So, to what extent is handling happening outside the country, and how does this connect to private international law is a very significant question here. Now, whenever we talk about, why is the question of private international law flagged here? Yes, it is flagged because there is an issue of a contractual relationship between two parties, and the contractual relationship also identified a forum for possible dispute resolution. So, that's where the private international law connection comes in here. Right. So now what we are essentially seeing between this whole issue of a data company, a data management company, a state, and a concerned citizens group is basically this. There is a triangulation of the whole idea of how data is understood here, right? On one side, you find the economic interest that is linked to the cross-border data management that is happening in this particular case with Sprinkler LLC, right? On the other hand, when you look at the state, there is something called a security interest of the state with related to the data, right? And then the third, then there is something what we would call as the individual privacy, right? So geographically sensitive, confidential data also having an economic impact. So this is where private international law today is called upon to address the contractual relationship related to matters having a security, geographical, confidential. I mean, the whole idea of private international law, what first comes to us is to identify the lex causae, right? What exactly is the law that is applicable to the cause of action? Right? And here, whenever we try to extrapolate this understanding of lex causae to private international law, our key question comes up, which applicable law? Now apply this traditional logic to the issue of this particular data management. But maybe data related to me explaining the whole genealogy of the South Asia, of a particular race, could be located in that, right? And secondly, the public interest of the state. Right? So, and then there is a securitization aspect to it, right? So, it's public international interest that we are talking about. Now we are handling them through the traditional lex causae mechanism, right? Now, unfortunately, we do not have a lot of public international law instruments addressing data and data governance, because despite the fact that data flows across the borders are such a common feature, right? Now, for example, you all know that whenever you check in into the airports, right, they are collecting data about you. Right? And these data could vary, these sets of data that are generated out of this piece of information that you are giving, they could be held in any form, right? And by any entity. So how exactly do you identify a lex causae here? Because the act, the cause of action is actually not connected to any one jurisdiction, but could be connected to multiple jurisdictions. Right? So how do we address this? And unfortunately here, what happens is that there is no standardized understanding internationally. You have these examples coming out of various jurisdictions because every jurisdiction feels that data is both security as well as money, right? I mean, we all know that information is the biggest commodity today. Right? So it brings a lot of value, economic value to the state, apart from the security interest that is there. So the triangle that I have pointed out between the data individual, the economic interest and the security interest. Now, these are to be married with the private international law concept of party autonomy. Right? Now, the sprinklers case actually tells us that one of the most important problems that we face here is with regard to the confidentiality of the data. Now, we cannot say that data cannot be exported, right? Because that is impossible. Whenever we are talking about, say, international dispute resolution, obviously there will be a data export between jurisdictions, right? For example, you're talking about international arbitration. Right? So the data could be located with the arbitral institution, which is administering the dispute resolution, or in any other manner, in case it is an ad hoc arbitration. But data exports and imports are the reality today. So how do we actually address the idea of regulating this export-import of sensitive information? Now, again here, the problem that comes up is, what is sensitive information? There is again no uniformity, right? But then these kind of problems cannot actually stop the business from happening, right? So how are we currently addressing these problems, right? Now, I would kind of quickly give you the ideas that we have, and then possibly if there is a few minutes left, then probably we can have a small conversation on that. So our current research actually makes us understand that there are regulatory mechanisms that help us understand how data is transmitted in cross-border economic activity where the regulation happens. So unlike other aspects that private international law addresses, as far as data is concerned, the problem is that much more heightened here, because every country takes the data protection activity as a part of the mandatory rules. Right? So whether you look at the European GDPR, whether you look at the America's privacy laws, whether you look at the China's data protection, personal data protection law, or whether you look at the recent India's adventure with, and I call it as adventure, possibly another conversation can come in on that, right? So India's attempts at having a data protection law. So all of these actually consider that whether it is an economic activity or a non-economic activity, the understanding is that information that is actually concerning their citizens is a part of the mandatory regulation. Now, how did they come to that understanding? One very simple term, which as lawyers and students of law, we are all very, very clear about, and that is public interest, right? So the countries believe that there is an essential parens patriae understanding about how the information about their citizens need to be regulated. And this is not exclusive to the DPDP Act alone. Every country believes it. Every jurisdiction, including the European Union, actually believe this. Right? It is only the manner in which they understand this regulation that is different. Right? So when they bring in the idea of the public interest to it, then all regulatory activity concerning data protection goes into the mandatory rules. Right? And then the question that comes up, how does the economic activity get impacted by this? I'll give you just one single context to this, right? Like if we take, say, for example, international arbitration. Now you might ask me, how are you classifying international arbitration as an economic activity? Obviously, because it is the part of the business of dispute resolution. Right? So dispute resolution is no longer that very, very glorious activity. But as students of private international law, we look at dispute resolution as a matter of business as well. Right? You look at every country you name in the world, they are now coming up with something like an international commercial code or an international arbitration center, or both of them. right? Now, why do they do that? Because the heightened trans-border commerce also leads to more disputes. And if there are more disputes, there are more activities around dispute resolution. And therefore, let us also take the part of the pie of dispute resolution, right? And that is why we are starting these dispute resolution centers all around, right? A dispute resolution center doing work related to transborder commerce, transnational commerce, can only be successful if the laws of the country, especially the mandatory laws, are very, very strong, right? Now, in the context of data, we have placed that because of the public interest understanding, data protection laws go into the area of mandatory rules. Now, within those, any private international law related activity, as in trans-border commerce, has to take care of a few things, right? One, it has to clearly ensure that it is complying with the mandatory rules related to data. Now, how do they do that? In the case that you are actually looking at an institutional arbitration, every institution worth the name today, which offers the services of arbitration, right, has a separate set of rules related to data. And they ensure that every time a contract for arbitration is finalized, right, they look at the siege of arbitration and try to adapt their rules to the mandatory requirements related to data at that point, right? Apart from this, right, now those are coming from the institution, right? And we all know that in the hierarchy of rules that are applicable at this for an arbitration, right, we also know that first we have to look at the lex arbitri and how strong is your mandatory rules related to data protection in that. Right? So within that, the things that are needed to be addressed are basically what we call as two major aspects. One, the data minimalism, and secondly, the data localization, right? Now, data minimalism is that right at the beginning, whenever you're framing an arbitration agreement, you have to broadly set out what is the least amount of data that you are asking for. Right? You just cannot go beyond that threshold unless you take permission from the local data authorities. Right? So this is like, you just have to specify in detail the least minimum data that is going to be required by you for any arbitral process, right? And secondly, all processes of data handling, data export and data handling have to be coming in tune with the data localization rules, right? Now, data localization has become a very fancy idea for many jurisdictions under public interest, and while it is criticized at a very public international law understanding, now in private international law we have no path except to go with the data localization, because countries believe that it is their data and therefore there is a security interest and therefore there is a value for them to exercise that rule related to parking the information about the data that is handled on their territory locally. Right? Now, herein lies a little bit of a difference between the European mechanisms and the Indian mechanism that is proposed, because data localization, while it has been discussed with the government of India, has not yet been introduced within the DPDP. Right? That is the 2023 legislation. Right? In the European Union, the assent is much more on data minimalism and also trying to ensure that if the data is going outside Europe, countries will, or contracting parties, right, will have these standard contractual clauses assuring that the legal system which is receiving this information, right, where this information is going to be processed, is strong enough to handle it, or it is very similar to the protections that are available to this one. Okay, so I'm sorry for that sound. Okay.
Ma'am, sorry to interrupt you, but we are in a bit of a paucity of time.
Calling me from the VIT. Okay, if they can switch off the phone, that would be better, because I'm not able to disconnect the call here. Yeah, so I got it. So yeah, so the whole concentration in private international law has to be to address the security of the data, and this is done through standard contractual clauses wherein the parties take all responsibility to actually ensure that there is all the protection that is available for the data subject, from the jurisdiction where the data has been collected to where the jurisdiction where the data has been used. So the things I would say to conclude, what we would really want to understand here, what I would say that private international law today has to encounter is to ensure that the contracts or the cross-border, transfer of economic activity also factors in the data law as a mandatory part of the law. So party autonomy restrictions do come in from the mandatory law on data protection. Thank you very much.
Thank you, ma'am, for your sharing your valuable insights with us. It was indeed a very knowledgeable lecture. Next up, we have our second keynote speaker, Professor Dr. Y.S.R. Murthy, sir. Professor Murthy is a renowned academic leader, institution builder, and a formal civil servant, currently serving as the Pro Vice Chancellor at SRM Institute of Science and Technology, Chennai. With nearly 4 decades of rich and diverse experience, he has made significant contributions to legal education, public administration, and human rights discourse in India. Over the course of his illustrious career, he has several prominent leadership. Okay, over to you, sir.
Moderator, Professor Kritika Sahu, my fellow panelists, esteemed members of the EC of ICPIL, Dr. Luther, Additional Secretary, Legal and Treaties Division, MEA, faculty members of VSL, and dear students. At the outset, I want to compliment Dr. Chakka Banerjee, Dean, VSL, for conceiving this conference and then making painstaking arrangements to get together a galaxy of experts and organizing this conference. And I have been asked to speak on the influence of artificial intelligence, the metaverse, and blockchain on the evolution of legal doctrines in private international law. I don't have any qualms in admitting that I am not an expert on private international law, and a lot has already been said by many distinguished speakers on the challenges and also the issues. I'll try to add a footnote to what they have said, and I wish to outline some issues and formidable challenges posed by the AI, metaverse, and blockchain. These technologies not only create new fact patterns for private international law, but they're also actively reshaping its core doctrines of jurisdiction, applicable law, recognition and enforcement, party autonomy, legal personality, and procedural cooperation. For long, our legal system has worked on the premise that cross-border disputes can be mapped onto territorially located persons, acts, assets, and courts. That assumption of private international law faces a challenge because AI can make decisions without meaningful human intervention. Blockchain can decentralize transaction architecture and obscure territorial anchors, and the metaverse can create immersive cross-border environments in which identity, conduct, and harm are not grounded in territory. As a result, we see the need for private international law to transform from a law of territorial conflict into a law of networked governance. In practical terms, private international law is being pushed to decide not only which state's law applies, but also where is the relevant act located, who is the relevant actor, and how can a judgment operate against a decentralized or distributed technological structure. Several classical private international law doctrines face a challenge. The most visible pressure is on jurisdiction. Traditional tests such as domicile, habitual residence, place of performance, and place of damage become harder to apply when the transaction is executed by code, the platform is globally accessible, and the users interact through avatars or pseudonyms. Blockchain-based and metaverse-based interactions often lack a clear territorial center, while AI systems may generate effects simultaneously across multiple states. Applicable law is equally disrupted. Private international law usually relies on connecting factors such as the characteristic performance, closest connection, or lex loci rules, but these presuppose a relatively stable characterization of the transaction and its parties. The digital economy complicates characterization itself. Is a smart contract a contract in the ordinary sense? Is a token a chosen action, a commodity, or a security? And is a metaverse asset a service, property, or license-like entitlement? Recognition and enforcement also become more difficult. A judgment may be formally valid, but practically hollow if the relevant asset is controlled by a private key, dispersed across ledgers, or held through a decentralized autonomous organization-like structure in a blockchain without a conventional legal personality. Private international law, therefore, increasingly needs interoperable standards, not merely bilateral conflict rules, if judgments are to be effective in digital disputes. Let us first look at artificial intelligence and related doctrinal change. AI affects private international law first through attribution. When an artificial intelligence system causes harm, is it the act of the developer, deployer, user, platform operator, or a combination of actors? The courts must determine how to treat that act. This challenges the ordinary private international law focus on a single legally relevant human actor and pushes doctrine towards layered responsibility, especially where design, training data, deployment, and supervision are spread across jurisdictions. AI also complicates the characterization of the wrongful act. A cross-border injury may result from autonomous decision-making, algorithmic pricing, discriminatory ranking, or content moderation failures, and each of these may fit differently within tort, contract, consumer, or regulatory categories. Private international law doctrine, therefore, is being nudged towards functional characterization rather than rigid formal labels. Finally, AI raises evidentiary and procedural issues with transnational importance. Algorithmic opacity can make it difficult to prove causation, fault, or foreseeability across borders, which in turn affects forum selection, interim relief, and recognition of foreign judgments. The deeper point is that AI is forcing private international law to become more comfortable with probabilistic, distributed, and explainable decision-making standards. The European Union Artificial Intelligence Act seeks to address some of these challenges. It reinforces a move away from purely territorial thinking in private international law toward market-based and effects-based regulation. That matters because cross-border AI disputes will increasingly turn on market access, user location, output use, and regulator responsibility rather than physical server location alone. AI Act is thus not only a regulatory statute, but it's also jurisdictional signal. It shows how modern digital regulation can extend legal authority across borders through the combination of output-based reach, representative requirements, and enforcement linked to market participation. Now let me turn to blockchain. Blockchain affects private international law more sharply through decentralization and pseudonymity. The absence of a centralized intermediary means that conventional jurisdictional anchors may disappear, while the use of wallets, keys, and addresses can make it difficult to identify the true parties or their place of business or residence. That creates serious friction for service of process, interim tracing relief, and the allocation of jurisdiction in cross-border disputes. A second blockchain effect is on contract doctrine. Smart contracts can execute automatically, but private international law must still decide whether the relevant agreement is governed by ordinary contract law or by code-based performance logic or by a hybrid of the two. That raises classical private international law questions about party autonomy, applicable law, and mandatory rules, but in a technologically intensified form. A third effect on blockchain is on property and enforcement. Since blockchain assets may not have a conventional situs doctrine such as lex re cite or the law of the place where the property is situated become difficult to apply in a straightforward manner. This has prompted us to focus on new proxies such as control, location of the intermediary, residence of the owner, or the law of the relevant platform relationship. Let us look at the metaverse and related challenges. The metaverse creates jurisdiction and choice of law problems because conduct, users, servers, and harm may all be located in different places, while current private international law rules often struggle to map virtual transactions onto territorial connecting factors. As a result, metaverse transactions are already generating cross-border legal issues in digital commerce and user interaction. A major issue is location. In the metaverse, it is unclear where the transaction, injury, or contractual performance actually occurs. This makes classic connecting factors such as place of damage or place of performance much less reliable than they are in ordinary offline disputes. Another issue is identity. Users may act through avatars, pseudonyms, or platform-controlled accounts, which complicates attribution of conduct and makes service of process, evidence gathering, and enforcement more difficult. Sovereignty is another important issue. States have different laws on speech, obscenity, harassment, gambling, privacy, and digital assets. As a result, in one place, hosted elsewhere, and legally consequential in several states at once. The metaverse also destabilizes the relationship between physical and virtual presence. An avatar may commit defamation, harassment, fraud, or IP infringement in a way that causes harm across borders. Yet, the ordinary territorial logic of private international law may not easily locate either the act or the damage. This pushes doctrine towards more flexible connecting factors based on effects, platform control, or the location of the targeted user. In addition, the metaverse foregrounds issues of consumer protection, privacy, children's rights, labor conditions, and safety in ways that are usually handled by public law, but now spill into private international law. The effect is to blur the traditional public-private divide and to make mandatory rules and overriding norms more central to conflict of laws analysis. The deeper problem is that the metaverse has global reach, but law remains nationally organized. Until states develop interoperable norms or a coordinated international framework, enforcement will remain fragmented, selective, and heavily dependent on platform cooperation. Here is the doctrinal evolution. The first doctrinal shift is from territory to connectivity. Private international law is increasingly asked to identify the state with the most meaningful regulatory connection rather than the state in which an act is physically anchored. This is visible in disputes involving platforms, distributed ledgers, virtual goods, and remote digital conduct. The second shift is from static classification to dynamic characterization. Courts may need to reclassify technological relationships as they evolve because the same platform may function simultaneously as a payment system, an exchange, a publisher, a custodian, and a marketplace. That plurality makes rigid doctrinal compartmentalization less useful than a context-sensitive functional approach. The third shift is from individual autonomy to infrastructural governance. Party choice remains important, but many technologically mediated relationships are shaped by platform terms, default protocols, code constraints, and technical standards that users do not meaningfully negotiate. Private international law must therefore address standard form cross-border governance rather than classic picture of two equal private parties bargaining over law and forum. Here are the 5 emerging doctrinal questions. Where is the relevant act located when artificial intelligence, blockchain, or metaverse systems distribute conduct across jurisdiction? Who is the legally responsible actor when the system behaves autonomously or semi-autonomously? What is the correct legal characterization of digital assets, smart contracts, avatars, and decentralized autonomous organization-like entities? Which mandatory rules should override party autonomy in digital cross-border transactions? How can judgments and interim orders be enforced against assets, systems, or participants that are decentralized, pseudonymous, or globally distributed? These questions show that the doctrinal evolution of private international law is not merely technical. It is normative because the law must decide how much uncertainty it will tolerate in the name of innovation and how much regulation is necessary to preserve fairness, accountability, and legal certainty. In conclusion, we see, as a result of these new technologies, a movement away from territorial conflict rules to digitally networked conflict governance. The traditional doctrines are not disappearing, but they are being reworked through broader ideas of effects, control, connectivity, interoperability, and mandatory protection. Private international law is becoming less about locating disputes in space and more about allocating legal authority across infrastructures. That shift will likely produce new treaty practice, stronger soft law, and more harmonized rules on jurisdiction, digital assets, and recognition of judgments in cross-border digital disputes. Thank you for your attention.
Thank you, sir, for your knowledgeable keynote address. I would next like to invite our third keynote speaker, Dr. Sunil Kumar Agrawal, who is a distinguished international lawyer and advocate on record before Supreme Court of India, currently serving as a partner at Agrawal and Associates. He holds a PhD in international law from JNU and has been affiliated with globally renowned institutions such as Hague Academy of International Law and International Tribunal for Law of Sea. So,
good afternoon to all of you. After the post-lunch session, this is the post-lunch session. I think I won't try to bore you, would attempt to, create some interest in the public interest law. We all know that as a lawyers, as a legal professionals and practitioners, we are all interested in disputes because that gives us the bread, that is a kind of earning livelihood for us. Before getting into the PIL subject matters, I think we deal with the dispute at 3 levels. Firstly, at the national level, generally where the advocates practice in the courts, we have the 3-tier system, as we all know, district level, then the High Court, then the Supreme Court. Then at the international level, sometimes the states too have the disputes among them, something that we are seeing presently between the US, Israel, etc. For that, we have the international institutions, ICJ, ICPIL, all these international judicial bodies are there. But when it comes to the most ignorant, I would say, the dimension of the dispute is when the parties are located across border, cross-border dispute among the individuals, private individuals as well as entities. That is what is the subject matter of the private international law, and that is the topic that we are discussing today. Okay, let me give the basics of, before getting into the issues and challenges in the emerging technology, I think we need to understand that PIL is very important because as a lawyer also, we sometimes deal with the issues where we are basically dealing with the cross-border litigations. For example, I give an example. Currently, I am dealing with a case in which interstate adoption case, not the adoption, this custody case, in which while I filed a writ petition before the Supreme Court of India under Article 32, I was required to file the affidavit as well as wakalatnama from the US-based my client. That has to be notarized not by the general notary that we have in our local system. That has to be notarized by our embassy or the consulate located in US. So that is the area where I think sometimes you as a lawyer also will be dealing some of the cases like the private, the disputes between private individuals, family disputes, or say the commercial disputes in which the 2 or more legal entities or the companies may be involved. The basic principles, as we all know, there are 3 elements that we need to understand when we are dealing with the PIL. First is basically the location of the parties. The foreign elements are very important. Once one of the party decides abroad in a different country, that means we need to involve the PIL principles. That is the first element. Secondly, the applicable law, because the conflict of law determines the applicable law. If it is not, agreed between the parties, then we have to adhere to the conflict of law principles to determine which jurisdiction will have the which country will have the jurisdiction to try that particular case. Otherwise, in most of the commercial matters nowadays, there is a practice, increasing practice to include an arbitration clause among the parties. That will, in that case, we can evoke the arbitration agreement or the arbitration clause could be evoked to institute arbitration tribunal. Depending on the seat, depending on the applicable law, etc. I think we had a session where in the previous session, the speaker spoke well on very elaborately on the arbitration matters, how they are dealt across borders, especially the recognition and enforcement of foreign arbitral awards in India, or how the New York Convention on Recognition and Enforcement of Foreign Arbitral Award, 1958, helps or facilitates enforcement of foreign arbitration awards. Third element is basically the enforceability. That is the crucial issue, because in the public international law matters, or the private international law matters, generally, even if a court of a country delivers a judgment, it is difficult to enforce in another country. And that is the issue, that is the crux. Because many of the countries are not party to the Hague Convention on Recognition and Enforcement of Foreign Judgment in Civil and commercial matters. That is the issue, and that is the reason many of in the commercial matters, generally we have the adherence to this arbitration clause. because that help us to evoke, as I told you, the arbitration tribunal could be instituted, and that will that award rendered by the tribunal would be considered as a foreign arbitral award, and that would have an enforceability in accordance with the New York Conventions. India is, as we know, is a party to the, in fact, many of the countries. It is the most universally recognized international instrument in terms of enforceability of foreign arbitration award, or in any terms in commercial matters, basically. And that is why it is considered to be very successful in implementing enforcing the dispute among two legal entities or the commercial entities across border. All right, so these are the issues I think we all have to be familiar with when we are dealing with some foreign element as a part of one of the party in the dispute that comes to us as a legal professional or a practitioner. The most important thing that we are dealing with today is not the discussion around the theoretical kind of structure of the PIL, but about the issues and challenges in the emerging technology landscape that we have today because of the emergence of the new domain called cyber domain, which has given rise to some transactions, something like digital transactions, facilitated with the kind of cryptocurrency in place. Now we have the cryptocurrencies. We have some smart contracts also being signed between the parties sitting across the border, and as well as the data protection, which is also important in the sense that the data which we are creating by using, say, the email or Gmails, whatever, you know, so many LinkedIn, etc., that is being processed by the tech companies. They use it because these data, which may not be we may be thinking that it's not much use to us, but becomes very important when they are processed and used, because these data are processed by big tech companies to identify the preferences of individuals. So that is the crux, that is how the data becomes commodities. And that has given rise to this idea of data protection. And now we have the digital rights also, like the physical rights, the human rights, or the all sort of rights as an individual that we have in the physical world. Similarly, we have now the concept of digital rights in, you know, like the data protection, the rights of the data originator, that is the data principal, how these are to be handled by the data fiduciary, that is the tech companies, intermediaries, etc. And there are guidelines. There are guidelines, there are regulations like the IT Act, which will all have now in place. In fact, most of these, another issue that we have is the harmonization of national laws. That is also very important when we are dealing with the PIL issue. Why? Because as we know, the different countries have the different legal systems, and definitely because of that, while litigating or enforcing any sort of judgment, the parties will have a difficulties in terms of processes and procedure to be followed, or the other things that the system mandates for them to be followed for implementation, etc. For example, in those cases, the institutions like UNIDROIT, institutions like UNCITRAL, institutions like Hague Conference on Public International Private International Law, all these institutions are working together and in terms of harmonization of national systems, national laws. For example, our IT Act is based primarily on the UNCITRAL model law on e-commerce. As we know, we were discussing about the legal validity of smart contract. All right. So how to deal with this thing? Because most of these contracts are being formed, entered into in the cyber domain through using the digital technologies. And that requires some sort of recognition recognition, legal validity of those contracts or those signatures. Otherwise, as a piece of evidence, whenever the dispute comes before the court of law. In that sense, that required legislations, and in that respect, UNCITL has done a lot of work by coming out with the model law on e-commerce, which was implemented by various countries, including India, in form of local legislations to validate or to legalize the digital signature, which is the crux of the smart contracts, or say the digital contracts, which basically we knowingly or unknowingly are entering into while dealing with these modern technologies, etc. In fact, our IT Act is completely, as I told you, is based on the e-commerce model law. All right. So similarly, this Hague Conference on Public Interest Law, that is also played a very important role in terms of coming out with this Hague Convention on recognition and enforcement of foreign judgments. That is important, though many countries have not signed it because of the various reasons. The primary reason why the court in one country hesitate to implement or recognize the decision of another court is basically the sovereignty issues, other issues, because no country would like to be, would like to give up their sovereignty very easily. There could be some functional cooperation in terms of say some sort of, now we have the letter regulatory for the, or some sort of through the AMLET, the mutual legal assistance treaties. But generally, it is very difficult to implement the judgment of a foreign court in a local or the national courts system. So these are the issues which are very important. Coming to this data protection issue, or the data, digital data, which has become a very bone of contention in the present era, I think that digital evidence and their admissibility, they poses the most important critical kind of problems in dealing with the disputes. Why? The reason being, as we all understand as a student of law, the evidence are very important to prove your case. As a petitioner or a respondent, we all have something to tell, and that has to be with some sort of producing evidence. Without that, court may not consider, and that may not be effective in getting the judgment in your favor. So that is why the collection of evidence, especially which are located abroad, becomes very important. And in this digital era, most of these data are stored abroad, not in the same country. As I know, most of these data which have been collected by these digital giants like Google, all these big tech companies, they are not stored in the same country. What has been collected from India may be stored somewhere in, say, Ireland or some other data centers. Data centers may not be located within the same country, and that will give rise to the jurisdiction as when it comes to the getting the digital data from the abroad. And that has become a very big issue. Still, there is no kind of a convention. There is no international cooperation mechanism. Still, we do not have much idea how to deal with this, except having some sort of a cooperative mechanism. That is what we are intending to do. In fact, till now, the Budapest Convention was considered to be very important to deal with the international cooperation on collecting the foreign located digital evidences. But nowadays, most of the countries, many countries in fact, like India, Russia, etc., they do not agree for the Budapest Convention. That's why the UN Convention on Cybercrime was adopted, but still we are not sure how effective it will be in terms of collecting the digital evidences located abroad. So these are some of the very important challenges that we encounter while dealing with, say, these issues related with cross-border litigation, etc. Another issue, the admissibility of these evidences, even if the evidences have been collected, because digital evidence, those who are familiar with the digital domain, it is very fragile, it is very difficult, because these evidences, generally digital data could have some unique features. They could be duplicated, easily it could be duplicated, could be made number of times, so nobody knows what is the original, whether it is the original, what is a copy, etc. So the issue comes whether they could be admitted as an evidence before the court of law or not. And for that, we need to create resources, we need to build the capacity, we need to do the capacity building, as well as we need to create the laboratories also. The cyber forensic laboratory becomes very important when we are dealing with the admissibility of digital evidences, which requires creating digital forensic laboratories across the country. Because of in India, we have basically very large population to cater to as far as the litigation is concerned. And though we have come out with little bit, I would say, we have taken a step to form, say, the legally recognized laboratory in terms of accrediting some laboratory. There is a scheme which has been rolled out by the IT ministry. So only the evidences which have been, say, certified or verified by these laboratories only could be admitted or will become a kind of admissible evidences. Rest of the whatever evidences that we collect or we bring before the court of law may not be admissible. That is the condition, that is, as we all know, is the section 65B of IT Act that mandates the digital evidence to be kind of verified by the forensic laboratory. These are some of the challenges that we have. Coming to this cryptocurrency, as we know, crypto is basically what? Cryptocurrencies are used for, it is used for some other, say, not necessarily for the commercial activities only. These could be used for criminal activities also.
Sorry to interrupt, but
yeah. So cryptocurrency has an important issue to deal with, that is the anonymity, because if nobody knows who has, it is very difficult to attribute that currency to a particular individual. So difficult to track the trail also, the money trail, difficult, and that could be misused. And that is because of the uniqueness of this, say, this cryptocurrency. And that is also one of the most important challenges that we have to face. And that is a cause of concern for us, because cryptocurrencies are also being used for criminal purposes, for terrorist purposes, as well for, say, buying narcotics also. So many issues are there. I think I would like to finally conclude by saying that PIL is not just confined to the three issues, the traditional issue that we used to discuss, something like the applicable law, the say the recognition, enforceability of judgment, etc. Now the area, that scope of these issues have broadened to include cross-border issues related with the data, as well as say the cryptocurrencies. These are some of the most emerging issues that we have to deal with, and we have to find solutions, because presently there is no instrument, there is no mechanism to deal with this, except kind of we can say that we need to develop international mechanism, cooperative mechanism, something like MLAT, etc. We can also have some letter regulatory could also be in the kind of could be done by electronic means if possible, because presently letter regulatory are not are basically done in a physical mode only. So some of the issues and challenges we have to deal with, and I just conclude. Thank you very much for such a this invitation, and would like to associate with the students, especially if in terms of any questions and answer or any future associations. Thank you very much.
Thank you, sir, for enlightening us with your perspectives. So due to paucity of time, we're not moving it with the presentation segment. I now request Assistant Dean VSL Anantu Esari to kindly come on to the dais to felicitate our keynote speakers. Thank you, sir. I now request Kirtika ma'am to propose the vote of thanks.
Thank you, Lasya. Thank you, sir. Now, I would like to end the session. As we come to the closing of the session, technical session 6, it is my privilege to propose a vote of thanks. I extend my sincere gratitude to our esteemed keynote speakers, Dr. Sunil Kumar Agrawal sir, Dr. Sai Ramani Garimella, and Professor Dr. YSR Murthy sir, for their illuminating perspectives and valuable contributions. Their expertise and depth of knowledge have greatly enhanced our understanding of the evolving dimensions of private international law. And my appreciation also extends to all our participants and attendees who've been so patient with their presence and engagement, and they have made the session meaningful and impactful. And of course, I would also like to thank all the people who've been involved behind the scenes in making this session a success. With this, we conclude technical session 6. Thank you all once again. However, please stay because next up is we have our valedictory session, which will be starting with in another 5 minutes. So I request you all to please be seated. And I request the dignitaries to please take their seats. Thank you.
Dear everyone, the chief guest is almost here. As soon as sir arrives, please stand.
Okay.
Good evening.
International Conference on Private International Law in the Era of New Emerging Technologies, Issues, Challenges and Way Forward, organized by VIT-AP School of Law, VIT-AP University, in collaboration with Indian Society of International Law. This conference has brought together scholars, practitioners, academicians and students for meaningful deliberations on one of the most dynamic intersections of law and technology. Over the past 2 days, we have witnessed enriching discussions, insightful presentations, and valuable exchanges of ideas that will certainly contribute to the evolving discourse in private international law in various fields. We are deeply honored by the presence of our esteemed dignitaries for today's valedictory session. We extend a warm welcome to each and every one of you. To formally commence the program, I now invite Dr. Banerjee Chakka, Dean of VSL, to deliver the welcome address.
Good afternoon to all of you. I hear very less, very feeble voices. Don't get disconnected in the connected world. Once again, good afternoon, all of you. Thank you very much. And indeed, it's a great honor and a privilege to have with us an esteemed member of our Private International Fraternity, Honorable Chief Justice of the High Court of the Sikkim, Sri Muhammad Mushtaq sir. He is an accomplished scholar in the discipline of private international law, having practiced and undergone the courses of private international law closely associated with Hague Academy of International Law. It is very pleasure to welcome our chief guest of this today's function. And I would like to take this opportunity, my colleague and friend, Dr. K.C. Soumya, the guest of honor from the Director of Ministry of External Affairs, Treaties and Legal and Treaties Division, sorry for that. And she has been working several years in the discipline of international law, and a brief tenure of her in Netherlands as the Counselor Legal at the Indian Embassy. She has been actively interacted with the Academy of Private International Law, that is Hague Conference of Private International Law. And it's my privilege and pleasure to welcome Director K.C. Soumya to the VIT-AP School of Law, VIT-AP University, for this valedictory function. And it's my pleasure to invite our esteemed Vice Chancellor, sir, Dr. P. Arulmozhi Varman, and who is the guiding spirit and who is very meticulous and constantly supporting us for conducting very impactful and meaningful sessions of conferences, research and teaching at VIT-AP University. I warmly welcome, sir, for your presence and presiding this particular event, valedictory session. And I also welcome our Honorable Registrar Sir, Jagdish Chandra Mudiganti. Due to some examination work, he just stayed back in the ground floor to attend to that. He will join maybe a little later. And he is also one of the strong pillars of support to create an academic environment and ecosystem to conduct an impactful events, to contribute the policy and regulatory mechanisms. Always he is one of the inspiring personalities in the campus. And I take this opportunity to thank him as well. And my esteemed colleagues, Dr. Anant Hesari and convener of this program, Dr. Bensha, colleagues, I welcome to all of you. Further, when we talk about international law, the first thing comes to our mind that Indian Society of International Law. We have grown up by associating with Indian Society of International Law as a student, researcher, as a faculty, and as an executive council member. And with that credentials, when I requested the Indian Society of International Law to come to the south of India, Andhra Pradesh, and they gladly agreed, and all the executive council members, and they are present today. I warmly welcome, I thank them for meticulous support for this occasion. And you must have seen the warmth shared by our Gerard sir and our Chief Justice. That's what all about international law. This is a little anecdote for us. And when we met people like, this kind of dignitaries, we take that an inspiration and we say that, yeah, we have the life to move beyond the structural limitations and interact with the people. So with this, I just, take only 2 more minutes to explain this particular program and why we are here and what we are doing and what we have done in the last 2 days and what is ICPIL and what is VIT-AP School of Law. So as we have been talking, technology convergence with the law is not a new phenomena, but there are a lot of issues. And that particular issues, today we have deliberated in the past 2 days, and we have galaxy of speakers, 18 keynote speakers going to give some kind of, long-lasting impact in the policy and the regulatory measures, not only in India, across the borders. And thank you very much, and definitely you will enjoy the deliberations on what we are going to have in the final valedictory session. Thank you very much.
Thank you very much, sir, for your warm words of welcome and for setting a tone to conclude this program. I now invite Dr. Anantu S. Hari, Assistant Dean, VSL, to present the conference report highlighting major events and achievements over the past 2 days.
Good evening, all of you. It is my privilege to present the report of the two-day international conference on private international law, which is organized by the VIT-AP School of Law in collaboration with the Indian Society of International Law and MLS and Company Law Firm. So this conference set out to explore a pressing and complex question, that is, how must private international law evolve in response to rapid technological advancements such as artificial intelligence, digital platforms, cross-border data flows, e-commerce, and cyber disputes. At its core, the discussions highlighted not only the challenges, but also the opportunities for developing coherent and adaptive legal frameworks. The conference also underscored the dynamic interaction between private and public international law in shaping responses to emerging transnational issues. We have received 163 abstract submissions, out of which 142 were accepted, and 63 full papers were shortlisted for presentation. And with 14 keynote speakers and 6 technical sessions, which is spread over 2 days, the event reflected the growing significance of private international law in contemporary discourse. The conference was inaugurated by Dr. Luther Rangareji, Additional Secretary at the Legal and Treaties Division, Ministry of External Affairs, Government of India, in the presence of Dr. P. Arulmozhi Varman, the Vice Chancellor of VIT-AP University, along with other distinguished dignitaries. The first day featured 3 technical sections focusing on contemporary developments in private international law. The first session examined the implications of artificial intelligence and digital technologies on jurisdiction, liability, and dispute resolution, highlighting the urgent need for adaptive legal frameworks. The second session addressed the limitations of traditional territorial connecting factors in an era of automated systems and AI-driven transactions. The third session expanded into specialized domains such as maritime disputes, biotechnology, and biodiversity governance. The paper presentations on the first day brought forward diverse and thoughtful themes, including AI and contract jurisdiction, crypto insolvency, digital evidence, data protection, space mining, and cross-border family agreements. Day 2 continued with the 3 hybrid technical sessions and 2 online sessions. The fourth session, that is the first session of day 2, focused on jurisdictional conflicts and the pressing need for legal harmonization in the digital economy. The fifth session addressed enforcement challenges related to foreign arbitral awards, cross-border data transfers, and compliance under multi-jurisdictional privacy frameworks. The sixth session explored global data protection regimes, ethical concerns in AI-driven legal process, and broader implications of technological innovations and international legal governance. So the conference reaffirmed a critical message, that is, private international law must continuously evolve to keep pace with the technological transformations, and highlighted the necessity for an adaptive, harmonized, and forward-looking legal framework capable of addressing the complexities of a digital and interconnected global landscape. Thank you so much for all the paper presenters and the keynote speakers. Thank you so much.
Thank you very much, sir, for the comprehensive report and for summarizing the remarkable success of this conference. We are honored to have with us Dr. Manimuthu Gandhi, sir, Vice President of ICPIL. May I now request him to kindly deliver his address as our guest of honor.
It is a privilege to address not only the gathering and sit along with the galaxy of lawyers, international lawyers and the municipal lawyers, most importantly with the Chief Justice of Sikkim and others. And I represent in this meeting ICPIL with my own colleagues, where I am a Vice President. And I think our knowledge, exposure to private international law that goes back to somewhere in 78, as far as I am concerned. And for Gerard, it would be 1 year earlier. But the Department of Legal Studies, University of Madras, it was the first institution ever introduced private international law in India in 1952. And while honoring the people here, we missed two names who are all closely associated with. One is Professor T.S. Ramarao of University of Madras. The second is C. Ramarao of Andhra University. They are towering figures in private international law, and we have acknowledged all others. And I wish to just refer that, keep in mind their writings also, because they are foreigners. It is worth spending time in all through sitting in the session, and it was really an achievement by VIT-AP University, and my thanks goes to the Vice Chancellor as well as the Dean Faculty of Law here, because such a wonderful session and organizing session was done in utmost very due diligently. It has been approached that all the papers that they have read here, all the keynote addresses they delivered, and their substance would equal to 10 books on private international law, 200 articles, research articles in private international law. Maybe students, when you are young, you don't understand this. That is what the weight of the conference is. In fact, many more conferences like this should be conducted by VIT-AP. Thank you very much for giving chance to share.
Thank you, sir, for your valuable insights and for strengthening this collaboration with your esteemed presence. Our next distinguished guest of honor is Dr. K.C. Soumya, Director of Legal and Treaties Division, Ministry of External Affairs. Dr. K.C. Soumya pursued her MPhil and PhD from JNU, after which she worked in International Committee of Red Cross, and later she worked as a legal officer in Ministry of External Affairs. She also served as Legal Secretary and Legal Counselor, Embassy of India in Hague. I respectfully invite her to address this gathering. Dr. K.C. Soumya, ma'am, please.
Thank you. Honorable Shri Justice Mohammad Mushtaq, Chief Justice, High Court of Sikkim, Dr. Arul Murivarman, Vice Chancellor, VIT-AP University, Dr. Banerjee Chakra, Dean, School of Law, VIT-AP, and Professor Dr. Gandhi, Vice President, ICPIL, distinguished guests, faculty of VIT-AP, and dear friends. Good afternoon. It's my pleasure to be part of this two-day deliberation on a very important and evolving topic. Over the past 2 days, we have extensively discussed a subject that sits at the intersection of law and innovation, private international law in the era of new emerging technologies, challenges and way forward. Thank you to VIT for inviting me to be part of this discussion. For me, these 2 days have been an enriching experience, listening to very prominent, eminent speakers and a few young minds. Speaking at the very end has always a strategic advantage. Everything that could have been said has already been said and discussed, and many a times more than once. So now I have this pleasant task of trying to sum up what has already been summed up n number of times very eloquently, but I'm going to make an attempt again. Traditionally, private international law has dealt with resolution of cross-border disputes by answering 3 key questions. This has come up during the discussions in the past 2 days n number of times. These 3 key issues were: which court has jurisdiction, which law applies, and how can judgments be enforced? These questions were once grounded in geography, physical borders, tangible assets, and identifiable actors. But today, that world has changed. Emerging technologies are stretching its foundations in ways that traditional doctrines weren't designed to handle. With the rise of technology such as artificial intelligence, blockchain, and cloud computing, transactions no longer respect territorial boundaries. A contract may be executed across continents in seconds. Data may be stored in multiple jurisdictions simultaneously, and parties may never physically meet. This transformation brings us to a set of significant challenges. This was, again, discussed very extensively, and every aspect of private international law has its own challenges, but I'm not going to get into all of them, but I would try to sum up a few. Firstly, jurisdictional uncertainty. When a dispute arises in a virtual environment, where exactly does it occur? Is it where the user resides, where the server is located, or where the company is incorporated? For instance, disputes involving platforms like Amazon involve multiple jurisdictions simultaneously. They involve multiple jurisdictions, making traditional territorial nexus test difficult, inadequate. Again, where does a dispute arise if data is stored across multiple countries? In our discussions yesterday and today, there were references made n number of times regarding smart contracts. Which court has jurisdiction when a smart contract executes automatically? Transactions are decentralized and anonymous. No clear place of contract formation and execution. Again, cryptocurrency, this was again discussed by our previous keynote speaker as well, operate outside traditional legal frameworks, complicating dispute resolution and enforcement. Also to say that cryptocurrencies are illegal in many jurisdictions as well. Second, applicable law in AI-driven decisions. AI systems may operate across borders with no clear location. If an AI system causes harm, which country's law applies? Should liability fall on developers, deployers, or users? This raises questions linked to artificial intelligence governance and accountability. Now, this concern of AI, let's say, taking over human decision exists in all spheres of international law. Well, in all spheres, and especially in international law, because that's our point of discussion today. States have been discussing about this, for example, in autonomous weapon systems, a completely different topic from a private international law, but on autonomous weapon systems for the past few years, basically to see when does a human interaction, when should it end, and when can machines take over. In my younger days, we had a movie named The Matrix. I'm not sure how many of the younger people here would have watched it. For us in late 1990s, that was a fantasy. That was something which we could only imagine. A machine coming from future comes back to this present world to undo and redo the existing course of history, which is a fantasy. But now that's something that is being discussed. Of course, not about a machine coming from future, but about a machine kind of having a say in the day-to-day activities and how much, whether a weapon should be allowed to automatically take a decision to bomb a place or not. So these are discussions that's been happening. Now, thirdly, conflicts in data protection regime. Different countries have conflicting data protection regime. For example, the EU's general data protection regulation versus India's, I would say, evolving data protection framework creates compliance complexities. Cross-border data transfers could raise sovereignty concerns, which was again discussed by one of the earlier speakers. Finally, difficulties in enforcement of foreign judgments. Even if a court delivers a judgment, how do we enforce it against digital assets, anonymous actors, or decentralized platforms? Emerging tech disputes often require cross-border enforcement. Courts may struggle to enforce foreign judgments involving digital assets in light of lack of harmonization, thus leading to uncertainty and delay. So the very feature that makes technology efficient, that is speed, anonymity, and decentralization, can also make legal enforcement harder, difficult. All this being said, these challenges are not without opportunities. Emerging technologies also offer tools to strengthen private international law. Online dispute resolution mechanism can make justice faster and more accessible. Smart contracts can reduce disputes by automating compliance. This morning, one of the speakers mentioned that AI could develop in future, not now, but could develop, wherein an AI would automatically order food depending on our body parameters. So for example, if I'm low on sugar level, then the AI is going to order Swiggy, call up Swiggy and order sugar for me or sweets for me, a sweet which I like. I'm sure the speaker actually meant this as a challenge, as a problem, because AI is doing things which you are not aware of. But personally, I thought that was a very interesting thought. I would love the idea that someone else is going to order food for me. I don't have to make a choice on what is the sweet that I need, but someone else is going to do it. And that is not the choice of the other person, but choice of what I like. I thought that was a very interesting concept, but of course there are drawbacks, but on a lighter note. So what is the way forward? Legal harmonization. This has been mentioned many number of times in the past two days. As no country can address these challenges in isolation, these challenges could lead to a momentum for legal harmonization. Institutions like HCCH, Hague Conference on International Law, based in The Hague, and UNIDRA are already working towards international cooperation in the field. However, much remains to be done. Here, I would cite the example of one of the convention which was adopted in 1980, decades before many of you were even born. So in 1980, there was a convention called Parental Child Abduction Convention. Again, another private international law convention. So now what is parental child abduction for the young minds here? The parental child abduction is where one parent removes from the custody of another parent a child without the consent of the other parent. So basically, the father take away the child or the mother take away the child. Many jurisdictions, including India, does not consider parental child abduction as an offense. Further, the jurisdiction to try such cases as per the convention is habitual residence of the child, which India, along with many other countries, are uncomfortable with as a link. Thus, the cases such cases are fought in two different jurisdictions. It could be in India and US or Europe, where Europe in one of the European countries which is a party to the convention. So the cases are filed, they are contested, takes long, there is really not much of a conclusive outcome. So why I mention this here is a convention that was adopted in 1980 still does not have universal acceptance. Now, the discussion on emerging technologies is still at a very nascent stage. I'm not saying the discussion starts today, but for the past few years, this has been going on. But then I'm not sure how long it is going to take before we would have concrete, harmonized legislations. Hopefully, it's not going to take decades. Next, update legal doctrines. Concepts rooted in physical territory must evolve to reflect digital realities, recognizing ideas such as digital presence and data location. Need for clear regulatory framework for emerging technologies, particularly around AI, accountability, and blockchain governance. Finally, it is equally important to strengthen cross-border enforcement mechanisms, ensuring that judgments are not merely symbolic but effective. Now for India, India's regulatory framework, such as Information Technology Act, reflects let's say, an evolving approach and may need further refinement to effectively deal with the modern tech realities. India may need to evolve towards a more forward-looking, tech-aware PIL framework while maintaining a balance between sovereignty, innovation, and global integration. In conclusion, the private international law stands at a very critical juncture. The digital revolution has challenged its foundation, but it also offers an opportunity to reinvent. The challenge before us is not to resist change, but to actively shape it, ensuring that the law evolves to deal with the demands of a transnational world. Thank you.
Thank you very much, ma'am, for your enlightening remarks and for sharing your expert perspective on the contemporary developments. We now proceed to the presidential address. I humbly invite Dr. P. Arulmozhi Varman, Vice Chancellor of VIT-AP University, to kindly address the gathering.
Thank you, ma'am. Very good evening to all. Yeah. Distinguished guests, eminent scholars, our respected delegates, members of the legal fraternity, and my dear student friends. It's a great experience for us. The last 2 days, there is a wonderful gathering on the international private law in the era of the AI and also the issues, challenges, and the way forward. Today we have one of the highly distinguished personality in front of us, and he is going to enlighten us through his vast experience and reach the greater heights of the Honorable Justice Mohammad Mushtaq, Chief Justice of the High Court Sikkim. Thank you, sir, for your kind presence today at VIT-AP University and upsetting the request and addressing to all our the younger minds to understand the very important level of the concept that has been proposed by the entire VIT-AP School of Law in collaboration with the Indian Society of the International Law. They are organizing the 2-day international conference in a very important level of the 6 sessions, and all the panel of the speakers, they have enlightened the entire audience with their vast experience and the new perceptions in terms of the private international law in the era of emerging technologies. Today we have the distinguished guest, Justice A. Muhammad Mushtaq, born on the June 1st, 1967 in Thana, Kannur district of the Kerala, a jurist of the considerable standing who current services as the Chief Justice of the Sikkim High Court, the smallest high court in India with a sanction strength of just 3 judges. His appointment in the January 2026 brought a court to its full sanction strength to the first time in the recent years and has been widely viewed as a significant step towards reducing the case pendency and improving the judicial efficiency in the state. He is an internationally distinguished personality and obtained his LLB from the Vaikunta Balika College of the Law in Udupi, Karnataka, and his LLM in the Labor Law from the Mahatma Gandhi University, Kerala. He subsequently pursued specialized studies in the space and the telecommunication law at the University of Paris, attended a course in the private international law at the Hague Academy of the International Law, completed an advanced program in the e-commerce and intellectual property with the World Intellectual Property Organization and trained as a mediator by the European team in association with the mediation of the conciliation of the Project Committee and Supreme Court of India. Dear friends, you might have understand that why the Honorable Justice is sitting here. He is one of the right person to address in the gathering and to enlighten all the younger minds and to bring everyone into the platform, and whatever the points that has been discussed, how the students from the School of Law is coming up with the reflection, that is what we are going to look at. Let me recollect that law must evolve not only with the society, but ahead of it, anticipating the future, it seeks to regulate. Okay. As all the distinguished speakers, they have addressed the key challenges before us in terms of the judicial complexity, in terms of the AI in the territorial boundaries, and the making the judicial principles increasing the inadequate, accountability and the liability, determining the responsibility among the developers and also the users, and the platforms remains legally ambiguous in terms of the digital transactions, regulatory fragmentations, that how it has to be controlled through the national laws and create the enforcement challenges, risk and the regulatory arbitrage. So in addition that, we also consider about the ethical and the human rights concerns, balancing the innovation and the privacy, fairness and the transparency is crucial. We have the distinguished guest of honors, Dr. Manimuthu Gandhi. He has already touched upon in the inauguration and followed by the various sessions. And we have the panel of experts from the ISL. They have already covered the various topics and beautifully summarized by the Dr. K.C. Soumya, the Director Legal and the Practice Divisions from the Ministry of External Affairs. We are all very eager to listen that our Honorable Justice Mushtaq going to address us in this gathering. As an institution, as the role of the university, what we are going to work along with the School of Law, that is where I am going to touch upon. Yes, rightly mentioned, foster the research at the intersection of the law and the technology, how the engineering domain and also for the law school can work together, and equip the students with the multidisciplinary level of the competencies, and also serve the thought leaders in the shaping the global legal level of the discourses. At VIT Amaravati, we committed to nurturing such an innovation-driven scholarship and contributing a meaningful and the global level of the policy dialogues. I am sure that all the students and the research scholars and the faculty colleagues, they had the wonderful exchange of the ideas, and they had the consensus with respect to all the sessions, and they had the good relevance in terms of the global context with the international level of the speakers. So they have highlighted what the AI domain is going to work, and whether it is going to enhance the legal predictability and the consistency, or improve the access of the justice globally with respect to the technology, assist in harmonizing the complex level of the legal system. The most important thing is why the AI in every field that the people are looking is it is a data-driven level of the mechanisms. Okay, I am sure that all the experts really touched upon how the technology can be blended with the domain expertise and bring into the society into the empathy, and also for serving for the humanity purpose. So I wish and congratulate the entire level of the two-day international conference. The collaborations with the ISL, it's really a tremendous level of the support for the VIT-AP for organizing such an international level of the conferences at the campus. Our students are very fortunate to hear from all the panel of judges, and also for the panel of speakers for the wonderful level of their addresses. This collaboration has to continue, and I expect that this is the beginning, and then we should move on further to evolve as a policy level of the decision makers in this part of the world. So I wish all the team, those who have contributed for this, the effective execution of this ISL. It's one of the demonstration of the collaborative effort, and they showcase the best level of the executions in terms of the international conference. So they set the benchmark for the people to focus on this. So thank you all. Jai Hind. Thank you.
Thank you very much, sir, for your visionary leadership and your kind words. The most awaited moment of the evening now arrives. It is my proud privilege to introduce today His Highness Honorable Justice Mohammad Mustaq sir. Honorable Justice Mohammad Mustaq sir was born on 1st June 1967 in Kannur. His Highness obtained law degree from BB College of Law, Udupi, and obtained LLM from MG University in Labor Law. His Highness enrolled as a lawyer on 1st October 1989 and practiced 7 years before various high courts and statutory authorities in Kannur. His Highness obtained second master's degree in space and telecommunication law, a funded program of French government from Paris, and also pursued private international law course from Hague Academy of International Law. His Highness also pursued advanced course on e-commerce and intellectual property from WIPO. His Highness was trained as a mediator by European team from UK and also by MCPC of Supreme Court of India, and has numerous international publications to his credit, including papers presented at International Astronautical Congress held in Hyderabad, Korea, Naples, Italy. His Highness attended various professional advancement courses, international conferences, and workshops on subjects relating to law. Practiced as a litigation lawyer, arbitrator, and served as mediator of Kerala Mediation Center. His Highness was standing counsel for Kannur University, appeared for educational institutions, telecom companies, local authorities, and etc. His Highness practiced in civil, commercial, constitutional law, administrative law, criminal law, telecommunications, IP, and IT laws, and was also a faculty for training on mediation with IIAM, Indian Institute of Arbitration and Mediation, a panel arbitrator for ICADR and IIAM, and member of International Institute of Space Law and Indian Institute of International Law. His Highness worked as Managing Director of online news and legal newsletter Link, published in Luxembourg, Charter Member and Treasurer of India International ADR Association, and Secretary of Mediators Council of India. His Highness sworn in as Additional Judge of High Court of Kerala on 23rd January 2014 and was appointed as Permanent Judge of High Court of Kerala with effect from 10th March 2016. His Highness was appointed as Acting Chief Justice of High Court of Kerala with effect from 5th July 2024. His Highness sworn in as Chief Justice of Sikkim High Court in January 2026. I now request Honorable Justice Mohammad Mustaq sir to kindly deliver the valedictory address.
Good afternoon to all. It's most difficult things to digest when someone addressed me as His Highness or Lordship. Whenever I get an occasion, I used to tell them, we are living in an era, we should shed those kind of salutation addressing it. And a young law student perhaps may think these are all the lessons required in the time. I don't think. So next time when you address, it is better to address by maximum you can call us sir, nothing beyond. Well, when I stand before today, I'm quite excited. Not because of my son is here, but seeing Gerard and many other whom I know long. It's a long association with them. I know. I try to understand the international, private international law and public international law. I'm not an academic expert in international law, nor have any great expertise as a practitioner in international law. But I was an onlooker. I was looking from the far and the fence. When I saw the Jayarajan speaking at many occasions, and I had a couple of occasions at Delhi, I was just trying to learn and figure out what is it. But I always think in terms of futuristic, and I try to understand things from that conceptual background. I just want to find out from where is my membership in ISL now stands. Because I used to pay 1,500 and I get 3 volumes or 4 volumes of book binded, the green, the bluish color book. But that apparently has disappeared now. So when I will seek your help to revive my membership, anything to be renewed, the color is changed, it's come digitalized form, digitized, that's what Soumya was saying. So I want to keep abreast with time, definitely. And if I require to pay a renewal fee, I'll pay and renew it. Definitely, of course, I don't want to vote and lobby for someone to get elected, but I want only something to learn from you all. That's all my aim. Well, Luther, I've seen him long back and maybe in Space Law Conference. Then when he moved to South Asia University for a couple of years, right? We met sometime. But these are all memory. When I saw them, it all came to my mind. Today, when I came here, I have a bare mind to speak from the bottom of my heart with my experience as a lawyer, student, and as a judge, and as a person in charge of computerization in both in Kerala and currently in Sikkim, and also part of NCM's team of Supreme Court while developing case management system for Indian courts. So I just look things from a different perspective rather than not an experienced person, but a learner. Well, I must congratulate the team here, the Dean Banerjee and his team, choosing this topic. I've been to many law universities in India. I don't know anyone that ever held any such program in a very futurist way of conceptualizing the subject. And I've not seen it. My more than 12 years experience as a judge, I've been invited many national law schools and spoke to many places, many law schools, but nobody has thought, maybe because of Banerjee's expertise in the international law. Maybe one occasion when I came here, I spoke about it, something about private international law. Perhaps he thought I would match his interest, but I don't know whether I would match his interest or expectation. But nevertheless, I had to speak. That's what when I see the youngsters, when I try to emotionally connect to them with my own perceptions and ideas. So what I had to speak to you today, you tell us, young mind, I believe you're all in the aspiration mode. When you want to get off law schools, you think something else. But when you step out from the law school, the first phase of challenge you face, no one would accept you, no one will acknowledge you. You might be smart. You will see there a lot of negativity and toxicity around. So life of a lawyer starts with all such scenario around. And it is through that phase one has to travel and reach that level. So it is challenging phase for everyone. No one would be there to guide you, especially in this era. I used to tell every youngsters, well, we are a lucky generation because we just look at our past generation. They were masters in their own way. So we try to emulate them. Their kind of practice, their kind of knowledge. We just browse through the paper, look, and everything we try to emulate. If you're smart enough to emulate, you're bound to succeed. But in new generation, you don't have any role models because you are living in the next level. You are in the fifth revolution where none of us can guide you. Where knowledge has become secondary, where ideas take preside over the knowledge. How competent you are able to generate ideas, that all matters for you. If you look at the life lessons around your world, you'll find that how the people who generate ideas succeeded rather than people who have knowledge. Of course, I'm not discounting the importance of knowledge. As an essential as a lawyer, you need to have knowledge. But as essential as a legal profession, you need to know have the ideas. This is how we can make a difference in this world. In a world, we have no certainty, and in a world, it looms with a lot of uncertainty. Everything is dependent upon how you shape prospectively, thinking in future terms. This is how the new challenges and new encounters have been faced with. So understand that you need to go back in history and understand how history, different challenges, each civilization passed through and how they were able to encounter and succeed those challenges. If you look at the past, long years ago, the small community we lived, everyone know each other. So there is no requirement to need to have a law because they know how to solve the problem. Then came the first revolution through invention of the agriculture. So people start concentrating a particular place where there is a plenty of water, fertilizers, or whatever the fertility of the land. Then, of course, they don't know each other, and the disconnection between them, disconnection among them, resulted in the creation of the dominant. The dominant then start dictating the law. So dominant say this is a law that people would accept. Then came the Abrahamic religion. Abrahamic religion tried to, impose law as ordained by the God Almighty. From Judaism, Christianity, and Islam, if you look at the different phase, how the Abrahamic religion tried to control the relationship, whether among the subject or subject to the state. In parallelly, our tradition, we were bound by not by any other such of kind of principle, but ultimate dharma. It cannot be equated with the modern concept of justice because that is, made the relationship in concrete because what is ideal conforming to the dharma is accepted as a justice. Then at the parallel, Greek tried to conceptualize justice, and the Socrates and Plato and all tried to, through dialogue, try to understand what is the justice. Then they came out an idea that is the virtue. So again, modern thoughts, you can find how the Rawls understood, many philosophers understood justice. Of course, this is not a subject of the today's dialogue, but what I want to convey you, each society faces its own challenges. Each civilization passed through the different challenges and they came out with the solutions. So if you look at the history of the common law, how that law was involved, it is because of the particular issue they faced, then they found solution that came later as a customs and tradition and part of common law jurisprudence. How the mercantile law developed is not that merchants followed the law. It is the law followed the merchants. The tradition and practice set out by those merchants later became part of the mercantile law. That means mercantile law followed certain things. So what was there in existence that has been adopted by a particular society was adopted as a mercantile law. So history in each phase, first from the agriculture phase, the first revolution, then in terms of when the invention of the industry that steam, that different phase. Then again to the bind the relationship of laborers and masters and all, then of course challenge they face, they had a law. So if you look at the history of the private international law, it was all necessity rather than it was invented for any other reasons. Private law is, of course, all might have discussed yesterday, it's a misnomer. There is nothing called private international law. It's all domestic law having an approach of an issue of foreign element. We have a princely states in our countries. We have a different laws in our country. The Bombay is different, Madras is different. Some places you can have 4 wives, some can have 1 wife. So that wasn't faced. If you look at the CPCs and judgments in Section 30 in the past, how the laws were developed in different places. So then issue arises, what is the choice of law, jurisdiction, etc. and enforceability. Similar issues, also grappled in Europeans also. So every places these challenges faced, then they found out choice of law and the jurisdiction, enforceable party, we should have some sort of understanding. So this is how private international law initially developed. Now that phase we passed through, and we are in the 4th revolution from the age of internet. Now we are moving to the age of idea. It is exactly something which you have perhaps discussed about in the cusp of the 5th revolution, where human interact with the machines, algorithm, because either the laws have been made to bind human relationship or human relationship with the state. Now we are moving to an era where machine would control our phase of life because we created and that controls our life. Every walk of our life, political, social, cultural, economical, every walk of our life, this is a big challenge. There is another challenge, perhaps we have remained unnoticed, that was a challenge consequent upon liberalization. That's economic liberalization post-90s. And you need to understand how the private international law developed through that post-90s, through the liberalization policies. So if you understood the past, because that in past, prior to the liberalization or the challenge now faced through the algorithm or in the era of machine, prior to all those challenges was something situational in the circumstances. That is how the private international grew with a limited sphere. But in the 90s, to create a market across the globe, the super norms have been passed through the legislations and many other phases, or treaties, or bilateral treaties, or multilateral treaties, and that conditioned the domestic law in parallel with the laws applicable to us. This is how UNCITRAL acted, the body related to the IPS, how they conditioned the local laws because of this, their understanding, and laid the law for it. If anybody thinks that the information technology is an act made by the parliament, yes, you are right. But if you look at the structure, it is not our legislative statements made. Its body is decided somewhere else. If you look at all the legislations, whether related to Electricity Act, we may think Electricity Act is an act of parliament. Yes, it's a parliament. But you look at it, it's decided by international body how a domestic market should behave to regulations. Because if you look at the UN resolution and many agreements, you find that how a consumer should be protected. Because when you open up the market, there will be market giants and they will consume the small market. So therefore, how their interest should be protected. They're all different matters. But you just look at it, how harmonization has happened across the market through international body. That is a phase of private and national law we often forget, because we just see the only phase of legislations. But that legislation is, in fact, is at par with the international understanding agreement. It is not a mere, it is, of course, it is domestic law, but by and large, it is agreed through various forums in WTO or GATT or other areas where the people have a convergence and idea how the market should behave. That is a phase of post-liberalization. If you look at VIT-AP, our current BNSS or BNS, you will find how the cyber security aspect is taken account. But still, we are not able, our parliament, of course, I'm not blaming them, not very basic issue in cyber threat and cyber security they could not address. If you look at closely the provisions of BNS, VIT-AP, if somebody is having it, just look at it. Section, I believe it, section 1.5 of BNS. It's corresponding to IPC, right? Yes, where it speaks about extraterritorial offenses. And look at the 75 of VIT-AP. It speaks about extraterritorial jurisdiction. It's, of course, it is an offense. Somebody, when the foreign national commits such crime, whether it's sitting in the Pakistan or UAE or UK or America and targeting our computer resources and network in India, yes, it is an offense. It's constitutes an offense. Though, and a long-arm statute would operate extraterritorially. But our parliament forgot to fix the jurisdiction for such crime. If you look at it, section 208, I believe, subject to correction. If you look at it, your academics are here. If you section 208 of BNSS, if you look at it, it only speaks about about Indian citizens or somebody is in the ship or something, aircraft or something. There is absence of jurisdiction for foreign national. Though there is a provision corresponding to 179 of that, what is that original criminal procedure code, now currently is 199, or maybe I may be mistaken of quoting the provision, where it speaks about jurisdiction, that is only local jurisdiction, identified whether it is in Vizag or Bhopal or Amaravati or Vijayawada. There is all allocation within the jurisdiction. But there is a total absence of a provision to try a foreign national for a crime referable under BNS or VIT-AP. That means our application to the foreign law or private international law not gone to their level of understanding it. I think currently Soumya is there. Just have a look at it, section 208. I'm not sure, maybe 208. If you read that provision, there is absence. Though we don't have a codified private international law, it's scattered either in Indian Succession Act, CPC, IT-Act, and these kind of enactments. But still, our application to mind, even to basic understanding of jurisdictions, absent. That's what I point out. So that is where the challenge we face. In that phase, harmonization has happened at different level. European Union. If you look at the European Union, how they try to harmonize, because that is all is a private international is all about. If you look at the history of privacy laws, it is not the European Union is first made. Maybe the right to oblique what existed in devised by French court in somewhere in 1930 or 48. Later in OECD, it came as, OECD countries, they charted out how the privacy law to operate. Thereafter, it came through the European directives 95/46 as the privacy law, the personal data related. Then, of course, it's replaced by GDPR. Currently, GDPR is GDPR, right? Is an operation. GDPR is in operation. And we simply borrowed those principles in Data Protection Act, which originally reflected in OECD document and the European Directive 95/46 and thereafter in GDPR. But anyway, those attempts is essentially to harmonize the law so that they can have there will not be conflict among the laws of the different country. That phase silently marched over and maybe somehow knowingly or unknowingly be embraced private international law or domestic law through these instruments and international bodies. But today I want to speak to you, sorry, I'm exceeding my time. No, the last part of it, how we're going to fix the issues of the future, the transformation part of the private international law. What we have discussed is all because of we face particular issues in the past and we try to fix through the private international law, whether harmonization through the international bodies or like what attempted in the European Union. But this aspect is a big challenge for us. The transformative of the private international law, in fact, if private international law is properly understood, it can have a big impact in the economic impetus of the country, especially a country like us. That's exactly the point need to be discussed and pondered by the law students. Of course, they have to sit along with the engineering students. You have a side by side, you have the departments here. That's exactly the issue. There are two ways looking at the future for you youngsters. One, look at the existing scenario, how things are operated through different regimes, especially in the cross-border transaction, cross-border market, we are all part of it. How many instruments we use, just Honorable Vice Chancellor was, we are discussing it. I said many instruments being used today, like for example, the export, how many instruments we use. Still, all the shipment, all bills all pass through the physical documents from bank to the shipper, host country, and the import country. If you have a blockchain technology in place, all being under loop and network, the simple transaction, the technology can be made by the technologists, but we need to have a private international law to tap those simple things. How difference it could make in the business. You just look at how the UPI and Aadhaar revolutionized in Indian economy, in financial sector. If you look at the current, the market of mutual funds, if you look at it, it's because of eKYC. It is because small technology, and when policy is followed by the government level, it ushered a new economic impetus in the country. Look at the changes. If you just Google and search and find out what difference is made, how UPI made the difference in the common man's life. Even if you don't have money, you carry your phone, it's enough for you. How it revolutionized the Indian market. Small efforts, but it's a big impact. The similar way the instruments currently being placed, used, when properly placed through the technology and legal frame, it can have a big impact in our country. I mentioned about the exports document. Just look at the scenario, everybody knows how the power of attorney works. Apart from the Hague Conventions and what is it, power of attorney is convention, I forgot it. Apostle conventions, where you need to have a seal of the notary to find out that's his genuineness, because he need not is done away with legalization or formalization through the embassies because of the seal. Why should we need to have such apostle notaries? If the blockchain can replace and understand the notary in the authority in America and have signed it, you don't require, because the blockchain is sure tamper-proof evidence. Any tinkering would reflect in the network of others. When I was in Kerala in the single roster, I've seen many litigations comes to before me. A foreign national wants to marry a Keralite. And registrar would insist, so the registrar means the registering office of the marriage takes place, that you should have a single, single certificate, that you should prove that you're a single or not married. It's impossible for a foreign national go back and search and find out a single certificate, whether he has to go back and get a certificate, or then we'll ask the certificate from the embassy to certify this in a bachelor's, because they were on the verge of marriage. They're given a notice under a special marriage act, and in search of it, ultimately they come to the court in 226. Where we have a foreign marriage act, I believe section 29, where we supposed to have a foreign marriage officer in the country, in foreign country. And seldom we appoint such officers in foreign country, and it's impossible to act through him. Why we do require such documents? If you have a marriage registers built in the blockchain, the distributed ledger technology, how the cryptocurrency works in that frame, it's as simple as that. Whether he is married or not, Gerard has got married in Seychelles or some other place will be known. So it is simple document, but what we need is understanding among the countries that we should have a law accepting that instrument, whatever the blockchain maintained is a law. So who has to make? The lawyers has to make. The lawyers has to part of that instrument, like what the UNIDRA is doing in Rome and Hague Conference doing in. We can also have similar bodies here in our country. They can push intergovernmental bodies and governments to accept. The technology is simple. But if law put an aid to such technology, it can have a far-reaching impact. Maybe youngsters think about starting up a startup and think about it, bring a technology in the place, get the aid of law. If countries accept it, that's as simple as that. So it can revolutionize existing part, existing scenario, existing relationship, or existing problems we face. We can have a private international law to resolve those problems. But last part of it is how we foresee the future. That's exactly the problem. In tort law, we developed the idea of principles of negligence, how a human and a prudent man act and rationally in a particular circumstance, because you attribute human intelligence, how a prudent man act, commission or omission. You all know the tort law. How do you ascribe such things to algorithm? It's only pattern. What human feed into it, it comes out of it. It doesn't have a subconscious mind like human. So it doesn't have a prudence like human. What is output? How it studies a pattern of volume of data, structured data, supervised structure, the study and brings out the output. It can't think like a human because we have a subconscious. I don't think there are studies goes and say that it will have an attribution like a human. I differ with that. A subconscious mind is a human and it's God's best gift to us, use intelligence. That's how we differ from the human, animal. The subconscious mind, you can't attribute. What's the principle of negligence? How do you attribute? If a robotic doctor commits some mistake, or driverless car commits some mistake because of bad signal it's received from GPS or GNSS or something else, you don't know. Can you attribute negligence? No, because per se negligence is something is attributable to only human. Human only in the loop. So maybe concept like foreseeability, because no programmer, no developer would come and say that I've developed this program because nobody would disclose this trade secret. That is the reason exactly in the European Union they made a law classifying high risk, low risk and medium risk because based on the consequence that may have. Because they also know that no program would divulge program results because that will compromise its trade secret. So it's difficult here. So we need to develop jurisprudence first. First, we'll have to develop jurisprudence like in Commonwealth, common law, how the norms develop in common law, how in Roman law. We'll have to think deliberation should happen at different level through academics and professors and others, how to develop a jurisprudence fundamentally. Replacing negligence would be difficult. That's what I said. Maybe the one common principle that can be easily accepted is foreseeability, because that one developer should have foreseen this would happen. That's maybe that could be the possible. And we also wholly had to relook at how the human rights law work within the frame. the principles related to fairness, idea of fairness. Again, we are at import. So these are the challenge for the academic body. Technology can go faster, but law cannot go faster because law always confront with human's life. So law can evolve only through ideas, like I would say that through ideas that to be generated through academics and academics bodies. And onus falls on you. That exactly I told you, in the past we could grow because we are looking at our past generation, just simulate, but you can't grow like, because we are nothing, we cannot share anything to you. You have to grow your own. That's exactly the problem. Fixing responsibility and idea of liability, what is the liability regime, what is the idea of responsibility, how you look upon it. The state responsibility forming part of just Gugans and parting of the base of international law, maybe to be rewritten in the era of algorithm, when especially in the IPR era, when you look at it, the challenges faced in IPR, it's quite enormous. My work can be replicated and through NT, what is it, non-tangible token, it can be passed to someone. And the third world country may own my picture. So there are a host of issues which perhaps I may not be able to explain. But problem again is how to start with it. Whether we should look at development of, look at the technology and look law thereafter, or law should precede the development technology is a matter for the country to decide. No developer, developer would take the risk of investing his money and thereafter finds that he confronted with the law. If law grows along with the technology, that ensures the steadiness of our country's growth. That exactly, we may face a lot of issues in cybersecurity, artificial intelligence, many areas you find there will be a lot of enormous challenges we face. These challenges is essentially to be addressed and responded by the lawyers and legal fraternity. No one else, no technocrats cannot say that I developed it because it's the best of the technology. Yes, they are the best of the technology. Still our country is grappling with the cryptocurrency, and we don't have law except for the income tax purposes. Income tax, of course, they found that they should pay the income tax, but we have not made any law legally recognize cryptocurrency as a mode of transaction, because they also find it difficult to have the law. So these are the challenges faced by modern society. The private international only instrument can play a transformative role. No other body can do that. It's a think tank of private international law will have to develop jurisprudence and law and instruments to put our country's fate to March of 2047's the one which we are now envisaged for the progress rate. So my youngsters, it is the lawyers that shape the country's destiny. In past, they had a limited role in shaping the country in the political, social scenarios. But today, your role is not confined to the political, social, but goes beyond shaping economic and technological face of our country. Honors falls on all youngsters of you. With this word, I conclude. Thank you, one and all. Jai Hind.
Thank you very much, Your Lordship, for your profound and thought-provoking address. Duly noted, sir. We shall definitely leave the colonial legacy behind. We shall now proceed to the felicitation ceremony as a token of gratitude and respect to our distinguished dignitaries here. Thank you to all our honored guests for gracing this occasion. As we approach to the conclusion of this memorable event, I now invite Dr. Bensha C. Shaji, conference convener, to propose vote of thanks.
A very good evening to one and all present here. Respected Honorable Chief Justice Muhammad Mustaq sir, Honorable Guest of Honor Dr. K.C. Soumya ma'am, Dr. Manimuthu Gandhi sir, Honorable Vice Chancellor Dr. P. Arulmozhivarman sir, Respected Registrar Dr. Jagadish Chandra Mudugandi sir, our esteemed Dean Dr. Banerjee Chakka sir, Dr. Anandu sir, distinguished dignitaries on and off the dais, delegates, faculty members, researchers, and my dear students. It is my proud privilege to propose vote of thanks on this memorable valedictory ceremony of our international conference on private international law in the era of new emerging technologies, issues, challenges, and the way forward, organized by VIT-AP School of Law in collaboration with Indian Society of International Law and MLS Company Law Firm. With profound respect, we convey our sincere gratitude to our Honorable Chancellor, Dr. G. Vishwanathan sir, and our Vice Presidents, Dr. Shankar Vishwanathan sir, Dr. Shekhar Vishwanathan sir, and Dr. G. Selvam sir, in absentia, whose inspiring vision and unwavering commitment to quality education continue to guide and strengthen all our endeavors. I offer our deepest gratitude to Honorable Chief Justice Muhammad Mustaq sir for graciously joining us as a chief guest for the valedictory session. A couple of months ago, when I had the honor of calling sir to request your esteemed presence for the occasion, the moment I mentioned that I was calling from VIT-AP University School of Law, sir, without a moment's hesitation, Dr. Manimuthu Gandhi sir, for gracing this occasion. Your presence, encouragement, and valuable insights have greatly enriched this conference and inspired all participants. We are deeply honored by your support. I offer my sincere gratitude to our Honorable Vice Chancellor, Dr. P. Arulmozhivarman sir, and respected Registrar, Dr. Jagadish Chandra Mudugandi sir. When we first approached your office with the proposal of this conference, you received the idea with encouragement and vision. Every line of the proposal was carefully examined and every detail was thoughtfully guided by you. That is what true leadership looks like. Leaders who inspire ideas, nurture excellence, and transform aspirations into reality. Thank you, sir, for your trust and unwavering support. I would like to offer my heartfelt gratitude to my Dean, Dr. Banerjee Chakka, sir. What began as a humble idea of 1 hour guest lecture for one of our newly joined PhD scholar gradually transformed through your vision and encouragement into a half-day workshop, then a one-day seminar, and finally into a 2-day international conference like this. I still remember our late evening discussions, intense brainstorming sessions, and your constant motivation for me to read more and explore private international law, even though I do not belong to the galaxy of international law. Your faith, mentorship, and leadership made this possible. You deserve our highest respect, sir. I also extend my sincere thanks to all the distinguished dignitaries, guest speakers, and representatives from the Indian Society of International Law, MLS Company Law Firm, and all collaborating institutions for partnering with VIT-AP University and strengthening the academic success of this conference. My heartfelt thanks goes to our organizing committee members, especially Dr. Anandwas Hari, Dr. Angel Shaji, Professor Nidhi Nair, Professor Amuda Gulshan, and our chief student coordinators, Sai Teja, along with Purnima Rajiv, Lakshmi E, Pavan Sai, Abhijit S, Rajshri, Kartikeya, and many others. This conference became possible only because of your commitment, teamwork, and tireless support day and night. I also wish to sincerely thank all our faculty colleagues at the Law School, Dean Academic Research, Dean Academics, Director RAC, and all Deans and Directors of VIT-AP University, conference committee members, and departments including stage management, decorations, transportation, guest care, registration, food arrangements, discipline committee, all session moderators, technical and documentation committee members, and all coordinators whose collective efforts ensured the smooth conduct of every session. My heartfelt appreciation also goes to all our student volunteers, supporting staff, and the Office of the Vice Chancellor, Registrar, Purchase Department, Public Relations, CPRO, Transport, Guest House, Maintenance, and every unit that work silently but significantly behind the scenes. Thank you so much for all. To all our delegates, participants, and guests, thank you for your enthusiastic presence, thoughtful engagements, and valuable contributions that made this conference vibrant and meaningful. This conference, conceived in January 2025, has become a reality today after 16 months of planning, preparation, and eager anticipation. As we conclude this wonderful academic gathering, we carry with us new ideas, new collaborations, and renowned inspirations. With a heart full of gratitude, I humbly conclude my vote of thanks. Thank you, one and all.
Thank you very much, sir, for expressing gratitude on behalf of all of us. I would also like to take a minute to thank Ali Mustafa for having such a creative thought even in the classroom. Very creative kid. We shall now proceed with singing the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Please be seated. I request all of you to please be seated. Now I request all the members of ISIL and dignitaries to please come on the dais for a group photo. Sir, please, sir, please, sir. Sir, please, please, please.
They are principal, not me.
Please, sir. Oh, no problem.